2, 1.
Good morning, ladies and gentlemen. Welcome to the July 30th, 2025 meeting of the Board of Oil, Gas, and Mining here in Salt Lake City. Before we get started, there are just a couple of announcements. You'll notice that Paula Farber, who's been our board counsel for the past year, has moved on to a different agency, and so we have Gary White, who routinely works for the division, sitting in for her as board counsel until that position is filled. Secondly, we are missing two members today, Selma Sierra and Gordon Moon, but we still have a quorum, and so we will proceed with the meeting. And with that, I turn it over to our director, Mr. Thomas, for the briefing session.
Thank you. Good morning, Madam Chair and members of the board. Before I get into the briefing, I'd like to spontaneously call out Prior Director John Baza, who happens to be in the room today, and I'm not going to call him up to do anything. He could probably stand up here and give the entire report if he wanted to, but we appreciate him coming in and participating in the audience today. Not too much we're going to cover this morning. First of all, I want to give a brief update on the division oil and gas bonding rules. On July 7th, well, first of all, we received comments from industry, stakeholders, and the board this spring and early summer and created a second draft that included many of those comments, or we provided responses if we chose, or we realized we couldn't include some of those comments. But that was sent out to stakeholders and industry on July 7th, and we have not received formal comments back yet. I think there may be some commenters today, stakeholders who would like to provide some sort of, provide an oral statement or comment. But we look forward to receiving comments back on the second draft and then providing something to the board to review moving into late summer and early fall. Again, those rules were R649-1, which were the oil and gas definitions, and R649-13, which covered the bond requirements for the state. As everyone knows, and probably many members of the audience, these rules have not been meaningfully addressed since 2002. So it is appropriate to modernize these rules, especially given the changes that we've seen in the industry over the past 20 years, especially. And moving into topic number 2 on other. As I was preparing for this morning, I realized that the board, well, you solve a lot of problems and you hear about a lot of problems, but maybe you're not fully exposed to everything else that the division is doing. And as we start this fiscal year, which started on July 1, I wanted to give a brief update on some of the other things that the division is doing. First off, in no particular order, on Monday, Governor Cox drove to Vernal and visited with some of our field staff in a very honestly intimate setting. I think there was less than maybe 8 or 9 people in the room, including Governor and his staff, and spent about an hour just hearing and listening and sharing how the field and the oil and gas industry specifically has impacted that community. It was a good back and forth. We had a couple of local representatives from industry there. We had 3 or 4 oil and gas and mining staff there. Our own Orlin Wallace spoke eloquently and sincerely and had a great conversation with the governor. And it's good to know I can say that the Governor Cox fully supports the industry. He understands how meaningful it is to Utah throughout the entire supply chain, from refineries, the pumps, all the way back to the operators. It was a very good conversation, and we really appreciate him giving that time to the division and the industry, definitely. Some other things we have kind of in the pipeline within the division is, you may know, critical minerals are a big upcoming, or not upcoming, but a big topic on the national stage and globally. As the U.S. and the Department of Defense seeks to increase its national security through the supply chain of a number of critical minerals that are needed to basically build the infrastructure and the equipment we use in national defense. Wonderfully, Utah has most of those critical minerals available in some supply. I would say even the top 8 to 10 critical minerals are if not readily producible, at least viable in a short amount of time to be produced in Utah. Because of that, the state is becoming a leader or a center for critical mineral development in the U.S. The Division of Oil and Gas and Mining is working with the Office of Energy Development, the Governor's Office of Energy Development, the Utah Geological Survey, and the administrative staff, as well as the legislature and a number of other stakeholders, to figure out the best way to mobilize these resources and meet the national demand. The demand is probably going to be driven by the Department of Defense contracts in acquiring these. A lot of these critical minerals are not economically viable in a perfectly commercial world. They just cost too much to extract. But when you consider that how that plays into national defense, the federal government understands we need to make adjustments to ensure we have what we need. It's a real pleasure to be a part of that as we work with a larger team and provide those, or develop ways to provide those metals to the DoD. OGM is also heavily involved in modernizing permit reform on a state and national level. We're working with the Bureau of Land Management for our federal partners, as well as different agencies within the state to see if we can help oil and gas permitting improve, but also on the mining front. In the United States, on average, from initial concept and discovery to processing, we are at about a 29-year window for any given mineral deposit. That is, well, actually, Mr. James would probably know this better. That's an order of maybe almost tenfold over what some of our competitors are doing, or our sister nations. And I'm not talking about China. I'm talking about Canada, Germany, other countries that are frankly very similar to the U.S. And how do we streamline that? It's a complex problem for a complex solution for a long-standing problem, but we're going after it one bite at a time. How can we use artificial intelligence to alleviate a lot of the administrative burden and workload? That's a significant driver in this. As you know, with this current administration, Secretary Burgum especially understands this need, and the feds are driving policy changes to enable the states to act quicker, and the federal partners as well. It's a real pleasure to be a part of that, and honestly, I just happened to be here when this demand came up. But it's pretty exciting. We will say more from a specifically state focus. Something Governor Cox shared with us on Monday is ultimately the DNR, and specifically oil, gas, and mining, is about customer service for the people and the operators who produce and support the economy through oil and gas and mining. In that way, we are evaluating different mechanisms and ways to provide data to meet industry demand. The state, especially OGM, and the data we provide and can enable consistent and strong competition with the operators who choose to do business here. Frankly, with other operators and other plays in different states. It's vital, as you all know, that Utah continue to lead out on cost competitiveness, time to production in oil, gas, and mining. And the division is happy to be working with operators and the legislature to a degree to help provide that data. It's going to cost a little bit, honestly, but we hope to have new data sets available with industry feedback within the next 6 to 12 months, and I'll keep you updated on that. Geothermal. Geothermal is not under the Board of Oil, Gas, and Mining. Okay, I just wanted to say that for the record. However, we have skill sets here, especially with deep well development, that we can provide service to those other agencies. Currently, geothermal permitting and regulation in the state of Utah is under the Division of Water Rights. Division of Water Rights. This is because geothermal traditionally is a hydrothermal source, which involves a water right. As geothermal technology has grown to involve advanced and enhanced geothermal wells, that hot, dry rock, it's a new frontier, frankly, as to how we effectively regulate it without getting in the way of anything. The division is in talks with the Division of Water Rights as well to make sure that our expertise is at least available for that. Now, regarding correlative rights of geothermal energy and potential royalty disputes or concerns, I've got to tell you all, using your expertise and structure is on the table. The Board of Oil and Gas and Mining has definite expertise there in dealing with correlative rights and how to resolve royalty issues. Nothing set in stone yet, but we're definitely at the ready to provide that support. In late October, we will be having a 2-day field trip to Boise, Idaho, to look at their district heating model. As you know, I came here from Idaho, and they've been using district heat in their downtown area for well over 100 years. We're having a small team pulled together. We'll hop in a bus, drive up, learn about it, talk, spend a night at a geothermally heated hotel, go out the next morning, learn around, probably have lunch at a geothermal greenhouse, and then come back. And the transcript for these meetings is always very exciting to read. I'll say that I said house, not horse, but we all know the truth. Anyhow, board members, if you'd like to be a part of that, please let me know. We can make arrangements if you'd like to be part of that overnight. And a few other little housekeeping things, maybe not. The division continues to pursue federal funding to subsidize and support our oil and gas well plugging funds and needs. You all are aware Utah is wonderfully unique in that we don't have an extensive legacy of pre-1980 oil and gas wells to worry about like Texas and Ohio and Pennsylvania does. Because of that, our oil and gas bonding needs are different and I think in a safer place. That said, roping back to what we talked about in the beginning, we want to make sure that the oil and gas bonding rules are updated and modernized to first protect the people of Utah and then support an industry that's so critical here. That is the meat of what I have. I'll get into next month's agenda, but I want to make sure after everything I've just given that you all have the opportunity to question any of the topics I just covered. So anything you'd like to ask or inquire about?
Go ahead.
Okay. Do you have dates set for that October visit to Boise?
Thank you, Mr. Walker. I apologize. We're going to leave the morning of October 30th, which is a Thursday, and ideally be back here by 6 p.m.-ish on October 31st, Halloween. What a great day to have a overnight road trip. But given the calendar for Mr. Ferry and the Director of Water Rights, Teresa Wilhelmsen, those were the days we pulled together.
Okay. Thank you.
Thank you. With that, I'll move on. Next month's agenda. Our next meeting is going to be Wednesday, August 27th at 9 a.m. We have currently 4 dockets on that, but we'll see what happens as we move through the month. And that is all I have. If you have any further questions, let me know.
I'd just like to remind people that the September meeting, we're going to be in Vernal,
Oh, thank you. Very good.
just as kind of a heads up.
That's correct.
That meeting in Vernal will start at 8, so we can also attend the summit.
Good.
Board, do you have any additional questions for Director Thomas?
Very good. Thank
Very
you.
good, thank you. Now I think we're moving into public comment. Do we have anyone in the audience who would like to come forward and speak? Hello there.
Hello to the chair and the board. My name is Ricky Ranko Browning. I am president of the Utah Petroleum Association. And as Director Thomas had set up, I did want to share some verbal feedback, some initial feedback on the division's draft bonding rule from the UPA's perspective. Apologies that we haven't gotten you a red line yet. I anticipate that will be delivered to the division and the board by Monday. It takes a little bit of time to get our members all aligned to get a majority opinion to you all on a redraft, but actively working on that and coming very soon. I want to express significant appreciation to the board and to the division for the amount of time that has been spent on this. I do think we are moving forward in a direction that threads the needle between giving the state the tools and the resources that it needs without overly threatening the investment that the industry can continue to make here in the state. We were very happy to see some of the changes in this new draft. And just a reminder that UPA's membership covers a really broad range of producers: oil producers, gas producers, large, small, primarily federal or tribal lands, primarily state lands, folks that have more of a vertical well footprint, folks that have more of a horizontal well footprint. And there's some very significant differences in how this rule impacts those different groups of individuals, which is why it takes us a little bit of time to get to a majority opinion across the board on this rule. So overall, we do think that the revised draft is a very positive step forward. There is one key change in this draft that we have significant concern with, and you will see that in our red line, and that is the universe of wells used to calculate which tier an operator falls into, tier 1, tier 2, or tier 3. So just to clarify, I'm not talking about which wells we're actually bonding on, but just those wells that are used to determine which tier you fall into. So for context, we've worked through this long process, this multi-year process with the division, and everyone agreed, the division agreed, the industry agreed, that we needed a corollary for risk. How do we determine what is risk? The division felt that looking at operators' production footprint was a good corollary. But in this draft, when we've seen the significant change that we're looking at only true state wells, so only those wells that are not carrying a federal or a tribal bond being used to calculate your tier, that significantly reduces the universe of production, making it very difficult to meet those production thresholds for many, many operators. We also question whether it's still actively evaluating an operator's entire state performance, which matters, right? You're only looking at a very small subset or universe of wells when you're looking at those wells that don't carry a federal or a tribal or other bond associated with them. And so given the purpose of this was to look at this as a risk factor to evaluate and determine risk, we do think that the operator's entire universe of wells is a better corollary to determine that risk. Also, I think I'm confident it was an unintended consequence, but one challenge with that is it kind of artificially skews winners and losers here. So operators that have a significant state-only footprint, or operators that have more, particularly of a vertical and state or fee footprint, are going to be able to qualify for a higher tier much more easily because they can meet that production threshold. Whereas operators that have more of a federal or a tribal footprint, or more of a horizontal footprint where they're crossing jurisdictions and probably have other bonds, have all of those wells excluded from the universe that they can use to calculate that production threshold for their tier risk. And they are, I'm sure, unintentionally damaged by excluding a significant amount of their production from that calculation. So I'm sure those were unintended consequences. The reality is we have had our operators rerun the numbers, is we have had several operators that under this new division of state-only wells being used to quantify risk and determine tiers, are large operators, active, responsible operators that would be previously tier 1 operators now moving into tier 3. And there are multiple of those. And I don't think that was the intention. As you would look at those operators, I think they're folks that everyone would agree, those are very active, responsible, significant production that would definitely qualify them for tier 1 in any other universe. So I think it's just a maths problem that was unintentional. But that's going to be the biggest change that you're going to see in our proposed red line that we would ask for you to consider. A few other things that I want to talk about. with that change where we're taking the entire universe, if we move in that direction where we're taking the entire universe of an operator's wells into consideration to determine their tier, but only bonding on those true state wells, which is a defined term in the division's draft called a qualified well capitalized. Those are only wells that don't carry federal or tribal bonds, for example. We think you can streamline some of the definitions. We know that this was an early draft, but as we've looked through this, making that change would definitely allow a little bit more of a straightforward list of definitions. You're going to see a lot of red in that draft. Much of it is really just definition and terminology alignment to try and make sure that we're using terms consistently throughout. So don't be too perturbed by the amount of red lines. We also wanted to flag appreciation for the division in allowing a certain percentage of at-risk wells to come under the blanket bond. So in Tier 1, 20%, Tier 2, 13%, and Tier 3, 8%. We think that that is a significant improvement that the operators really appreciate in giving them flexibility in how they deploy capital and how they turn wells on and off in their portfolio for seasonality or market conditions or other things, while still giving adequate protections to the state. But with that, in the draft, the tier qualification has two qualifiers, one being production and one being your percent of at-risk wells. Now that you can have 20%, 13%, or 8% of at-risk wells under your blanket bond, we struggle a little bit with what that qualifier that still relies on your percent of at-risk wells is and how that would work and function. It seems a much more straightforward route, in our opinion, would be just to look at the production for the tier qualifier. And then if you have a percentage of at-risk wells that are beyond that 20, 13, or 8, depending upon which tier you're in, you have to get supplemental bonds for those. So we did tweak that in the draft that you will see. And then just a few other smaller changes. So on surface bonding, the division's new draft has a $10,000 per well site surface bond associated. For some operators that have a very, very large well footprint, this would quickly escalate to an extremely significant bonding requirement and would also be a very large administrative and paperwork burden for both the operator and the division. We have suggested a $100,000 cap on that, so $10,000 per site up to a cap of $100,000 for surface bonds to try and address that. And then a few other small things on the bonding schedules. We wanted to point out that inflation doesn't always occur in the CPI for oil and gas, so this includes an automatic inflation increase. This June, for example, we actually had a decrease, so you'll see a tweak in the language to adjust for that. On the requirements for bond release, we've also just tried to clarify the language a little bit so that we're all moving forward on the same assumption that those bond releases only apply to qualifying wells. Obviously, U.S.M does not have jurisdiction over releases on federal or tribal wells, and we didn't want to imply that and kind of upset the apple cart with our important federal and tribal partners there. And then one just very nuts and bolts thing, but a kind of a key thing to think about in our 649-13-7 requirements for bond release in little b II specifically, U.S.M has stated that they may notify the operator or the surface owner of an inspection. In the current rules, there's a conflict or a contradiction there. They say that U.S.M will conduct an inspection if no affidavit or release is provided, and it is the operator's responsibility to notify the surface owner of the inspections. So we wanted to make an adjustment there, but flag there's an inconsistency of who is notifying and who bears that responsibility. So those were our big picture things. You may see a few other things in the red line that we send through. But again, the biggest concern that we have is defining the tier and which universe of wells we are using to calculate the tier qualification and trying to make sure that we're taking a holistic view of the operator's performance and not artificially taking a more narrow view of the operator's performance. Again, extremely appreciative of the opportunity. I think we're moving in the right direction, at least from the industry's point of view. We appreciate that. Happy to answer any further questions and happy to answer any questions and continue to work with the division and the board when you receive our red line early next week. Thank you.
Thank you. Does the board have any questions for Ms. Browning?
Thank you for your comments there, Ms. Renko. On the entire universe, where are we, you're going to propose something new or different, I guess. Where are we drawing the boundary? Is it company-wide, nationwide, statewide? I know it's going to be in your reading, but I just want to clarify that before I read it.
Sure. Apologies for not making that clear. We're not actually proposing something new. We're proposing to go back to the previous structure in that regard. So it would be any well that the operator has in the state of Utah.
State. Okay. All right. Cool. And also on your surface bonding discussion there, the $100,000 cap, would that be, where does that apply? Per pad or per company?
Operator.
Per operator. Okay. Per operator. Okay. All right. Thank you.
Thank you.
Mm-hmm.
Do we have any other questions? Thank you. Do we have anyone else? Is there anyone else in the audience that would like to speak?
Yeah, Adam Peltz is supposed to be.
Okay. Don't see anyone in the audience. Do we have anyone online who would like to speak?
Hi. Yes. Oh, I'm sorry.
Our monitors are not on. We can't see the audience.
Stand by.
Thanks.
Adam, are you first?
I don't know who's first, but happy to go in whatever order the board would like.
So, yeah, Adam, let's go ahead and do Adam first, and let me get him online. Stand by. Okay, Adam, go ahead.
Great. Thank you so much. And first of all, I want to echo Ricky's comments and thank the board so much for their continued interest and work on this important forward-looking issue. I think overall, the draft we have in front of us is judicious, balanced, and risk-based, and I very much appreciate that. I hadn't appreciated that the scope had changed from all wells in the state to just state wells. And I would agree with Ricky that it should be the full well population in the state that's used to determine risk. That said, I think it's important to retain the at-risk well percentage calculation in determining risk and thus the tier. I mean, that's really what tells you the risk. The total production amount in a fleet is only half the story. And the other half is the level of liability and ability to pay for that liability. So with that said, I have two clarifying points. I want to make sure that I'm understanding this draft the way that you all are. So looking at 649.13.3.1A2, this is the section where a certain number of at-risk wells are allowed to be covered under a blanket bond. And I want to make sure that I'm reading it the same way that you all are. So I think the plain language read is that if a tier 1 operator, this is an example, has 1,000 wells, of which 200 are at risk, the blanket bond would cover 800 non-at-risk wells and 40 of the 200 at-risk wells, leaving 160 to get supplemental depth bonds. The reason I want to clarify this is because it is possible to read it another way, which is that if a tier 1 operator has 1,000 wells, of which 200 are at risk, the blanket bond would cover not just the 800 non-at-risk wells, but all 200 at-risk wells. And then no wells would require a supplemental depth bond. I don't think that's what's intended, because if so, then it seemed like it would gut the rule, at least for many operators. So I just wanted to clarify that it's the first reading and not the second reading. And the second point of clarification is, it seems to me like the draft includes inactive wells in approved shut-in or temporary abandonment status in calculating the at-risk category. I think that's the correct approach, and I think that's what the language says, but I just wanted to confirm that was your intention. We have calculated that if the interpretations that I just laid out are so, and if the well count is in fact the entire population of wells in the state and not just non-federal and BIA wells, then the total amount of bonds collected under this draft versus the previous one would be around 10% less. That's not so bad. But if there are further changes, that will be perhaps tricky for the state because the lower bond amounts collected will grow over time as the Utah well population ages and becomes less productive. So I would say you've landed on a pretty good setup, and subject to a little bit more understanding, you should stick with it. And then finally, I wanted to say hello to John Baza and share my appreciation for his decades of public service. Thank you, John. And that's it.
Thank you. Board, do you have any questions? Director Thomas, do you have any comments at this point?
Thank you, Chairman, and thank you, Mr. Peltz. I appreciate that. We will evaluate the comments you've provided and the questions today. I think you've sent some emails that as we work through all of this, we'll evaluate that and providing an updated draft. I must be able to provide some clarity to some of the topics you brought up, and that is, in case there's some confusion, a statewide well consideration is to consider statewide production. We won't be considering wells that the state is not required to bond in determining risk. That we are only going to calculate bond amounts on wells that the state would be required to bond. And the first point you brought up, the 20%, 80, the 1,000 well concept. In fact, if an operator is tier 1 and has 1,000 wells, 800 of which are in production, and 100 or 200, that 20% are not in production, then that would fall underneath the 20. Those 200 wells would fall underneath the state bond. So your interpretation, I think, I had to provide some clarity there to make sure you saw, and that is a significant consideration that we took comments from, your organization as well as operators and the board in determining this. It was not considered lightly, and we are still in draft. Just so everyone knows, this is still going to be up for some discussion. But in evaluating the tiers and the percentage, we wanted to consider the operator needs and weigh that against the potential risk to the state. We need to maintain a viable, competitive industry while protecting the state. And maybe not anecdotally, the large 1,000-well operators are not historically the ones who pose a risk to Utah. Honestly, it's Mick who goes out with 5 wells and decides to try to make a little money, right? And I don't own any oil and gas, for the record, and I haven't for years. But there's the example. We want to make sure we can focus the risk where the risk is, or focus the insurance where the risk is. And I also want to share this. I don't mean to have any sort of back and forth, and I appreciate you being patient there. Overall, under this new bond regime or schedule, statewide bonding does increase dramatically. It's a definite increase over the $120,000 blanket bond that we're currently under. So, the 10% up and down overall, there's a significant increase in state bonding to account for, frankly, the additional risk and cost of plugging and abandoning a well. I covered this, I think, month before last. It's not $20,000 to P&A a well anymore. It's $75 to $100, even with our staff as good as they are. So I hope that provides some clarity. And again, board, thank you for your discretion and allowing me to provide some answers to these comments. I'm happy to engage further if you'd like.
Thank you. Ms. Biltz, do you have any further comments?
We will run the numbers based on this new understanding. In fact, we already did. We found that would, if you interpret it the way that you just explained it, then it would be a 15% less than the last draft, we'll run the numbers again before we submit you written comments, just to make sure that we've gotten it all correct. But it makes me wonder, you know, why even have supplemental bonds in Tier 1 if no one's going to need them?
It's an open-ended question.
Yes, we do not have to resolve it right now.
Very good. Do we have were you finished, Mr. Wells, before we move on?
I am, thank you.
Thank you for your comments. I appreciate you coming to speak to us. Do we have any other public comments for right now?
Yes, Victoria, go ahead.
Please identify yourself.
Yes, my name's Allie West, and I'm listed here as Victoria. It's my middle name, and I'm not sure how that got on there, but I'm not sure if this is the point for me to address my issue, but
Ms. Sherwood?
yes.
I know you have several comments on item number 1 on our docket, but we'd like to hold your comments until
Thank you. That's the clarification I needed.
Yeah, until we
you.
begin that issue. But we will hear you here in just a minute. Thank you.
Thank you.
Do we have any further public comments from anyone online or in the audience? Seeing none, I think we will end the briefing session and commence with the formal hearing. Thank you, Director Thomas. We're now moving on to docket number 1 of the formal session. We'll give you guys a minute to set up.
We're ready, Madam Chair.
Thank you. We're going to commence with docket item number 1, which is docket number 2025-040, cause number 132-80. In the matter of the request for agency action of FOURPOINT Resources, LLC, for an order pooling interests, including the compulsory pooling of interests of certain non-consenting owners in the Shields 15-12, 3-3-13-24-1H, and the Shields 15-2, 3-3-13-24-3H wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formation in sections 13 and 24, 3 South, 3 West, Duchesne County, Utah. Before we commence, there have been several motions that have been filed in this matter. And so before we proceed with the compulsory pooling part of the hearing, we'd like to go through these motions and hear them. The first one that we'd like to hear is, let me just double check. Ms. Sherwood, are you online?
Yes, ma'am.
Okay, just checking to make sure you're there. The first motion that we'd like to discuss is the motion to convert objection to public comment. I believe that was filed by Mr. McDonald. Would you like to proceed with that?
Yes, Madam Chair. For entries of appearances, Fred McDonald of Counsel with Lear & Lear on behalf of petitioner FOURPOINT Resources, LLC. Would you want, hang on, Scott. Do you want the other appearances, Madam Chair, at this time, or?
Yeah, probably. Let's do everyone.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Ms. Sherwood, would you like to identify yourself again, please?
Yes, I am Alice Weston Sherwood, and I am objecting to this move by 4 points.
Okay, thank you. Do any swearing in? Will 4 Point be presenting during the motions? I'm just thinking about swearing in.
No, not our, that's not our intention,
Okay.
based on what's there. If, depending on your ruling, we may address that.
Okay.
And have it in testimony.
Ms. Sherwood, because you're going to be presenting testimony, we'd like to swear you in at this point.
Yes, ma'am.
Okay, please raise your right hand. Do you swear that what you're about to, evidence you're about to present is truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. McDonald, back to you. Would you like to commence, please?
Yes, thank you, Madam Chair. As you see in our motion, we request that Ms. Sherwood's whatever statement she make be treated as public comment as opposed to a proper objection, because her objections are irrelevant to the purposes of compulsory pooling before you today. The motion contains all of the documentation reflecting why 4 Point believes that Ms. Weston Sherwood's interest is leased. It is held by production, the lease is held by production, and that it has been properly pooled, and therefore it is voluntarily pooled. And she was, as a consequence, was not named as being compulsory pooled in this matter, and not declared as a non-consenting owner. So as a practical matter, no matter what the board decides regarding the motion, her interest is not affected here. I'm not, some of the basis for her original objection were the fact that she had some communication issues with 4 Point. She claims that the pooling clause has not been complied with. She also complains that she hasn't been paid, which we will be happy to address, but those are all matters that she can address through either litigation if she wants to claim a breach of contract, or if she wants an accounting. There's a separate procedure under the Utah Code, section 40-6-9, for her to bring her own request for agency action for an accounting, which the board is familiar with that procedure as well. But as far as the issues before today, we are dealing with the compulsory pooling of other owners that do not affect Ms. Weston Sherwood, and we had asked that the board therefore treat whatever she has to state, and we don't have any objection to her voicing her concerns, but they should not be considered an objection to this request given her voluntarily pooled status. Thank you.
Thank you. Ms. Sherwood, would you like to respond to that?
Yes, ma'am. I completely disagree and assert that I do have involvement in the matter at hand, and that it goes much farther than these things that he has listed. Um, uh, I have an objection by a law that I have found called unconscionable law, but the 4 Points and the oil company has asserted rights over me and my relatives through the years and years. And I believe most wholeheartedly that it falls under Utah unconscionable law, which states that there's a very unfair favor on one side. And I am here on behalf of both myself and my relatives. And I have a good number of other objections to put forward. I do have claim in this matter, as also my family.
Thank you.
And thank you.
We'd like to go through all of these motions, and then we'll make a decision after we've heard all of them on the outcome. But could we move ahead to the division? Do you have any comments on this particular motion?
As to the motion to convert, division's point of view here is that we're here today as part of a regulatory proceeding, which involves, under our definitions, an owner or operator to pool those interests in as much as any party has leased their interest. They no longer fit the definition of an owner. They've contracted those rights to another party. So I can't speak as to the specifics of what is being said, but as this relates just to a regulatory matter, it should only concern owners. And if you aren't an owner under that definition, then
I am an owner under that definition, and my pooling was involuntary, just as these relatives is involuntary.
Ms. Sherwood,
Yes,
could
ma'am.
we have you hold your comments until the presenter is finished? Thank you.
I don't have much more to say.
Okay.
I'll leave it there. Thanks.
Okay, if you'd like to speak now, Ms. Sherwood, that would be great.
I'm so sorry. Yes. My rights were involuntarily pooled, just as my relatives are being involuntarily pooled. And it's the same situation and the same scenario, and falls under unconscionable law with this oil company just going ahead and doing willy-nilly whatever they please without regards to the rights of the owners. And in fact, this motion is trying to be retroactive to 2016. And it is, I believe, an abuse, and a driller might try to retroactively apply these laws to unfairly cover up and make legal their faults and lacks of the past.
Ms. Sherwood, could I have you address each of the motions as we get to them? We have several matters here that you're involved with, and maybe we can move back and move on to the next comments. Finally, Mr. McDonald, do you have any final comments on this motion?
Yes, a couple things. First of all, Ms. Weston Sherwood is saying that she's representing her family. There's been no designation of that. I would object to her representation of anybody other than herself in this matter. Secondly, the issue, if she believes that it's unconscionable and wants to challenge the validity of the lease, the forum for that would be in a court, as well as her other arguments that she would make on it. It's not, as Mr. Haynes pointed out, within the confines of the request of action before you, and that's why we would say that anything she takes should be taken as public comment only. Thank you.
Thank you. I think at this point, we'd like to move on to the next motion. that was posed by Ms. Sherwood, the motion to postpone hearing. And I believe you submitted this, Ms. Sherman, and so we'd like you to explain the motion to us.
Yes, to postpone until I can have proper legal representation, because as I have asserted, this same thing that they are trying to do now, they've done to me. The pooling is not by consent, and I do argue unconscionable law that we just I and my family have not understood these proceedings. And I do have right to legal representation for this case. And the reason for postponement is that I would like to have legal representation. I'm disabled, and I fall under Utah Indigent Law of 2019, which requires courts to appoint a lawyer on my behalf. And I would request this.
Thank you. Mr. McDonald, do you have a response to her?
Yes, her argument about the appointment of counsel, if you read the statute, it's limited to criminal matters, parental termination. It does not apply to administrative actions before the state. It's also directing the county in a court system to appoint that if that's the case. So I would argue that that's an irrelevant point. And then as to the need to postpone the hearing, I go back to our prior argument that her objections are outside the scope of what was being requested here, and there's no need to postpone. Thank you.
Thank you. Division, do you have any comments on this motion?
No, the division has no additional comments and actually concurs with Mr. McDonald's comments. Thank you.
Ms. Sherwood, we are back to you for closing comments on this motion to postpone.
Yes, Mr. McDonald's comments left out the fact that I am right to counsel. It's not limited to those specifics that he claimed, but there is also I am allowed counsel without the necessity for cross-examination of witnesses.
Thank
The
you.
law does provide for that for me.
Okay, so we've heard that motion and we will consider it. Can we move on to the third motion, which is also Ms. Weston Sherwood's, on the motion to appoint a lawyer? Would you like to explain whether or not you've tried to obtain a lawyer?
Yes,
moving
ma'am. I
forward?
have very, very diligently tried many ways to obtain a lawyer. I've been very frantic to do. This matter means a great deal to me and to my family. We're all undergoing the same things here. And I have not been able to secure, at this point, legal representation. And I do implore you, Madam Counsel, to appoint one.
Okay.
Thank you.
Mr. McDonald, do you have any comments?
Nothing more than what I said previously, that the board is under no obligation to appoint counsel under the law that's involved here. She can have her own counsel, but again, there's no need to postpone for her to have counsel in this situation.
Division, do you have any comments on this motion?
No additional comments.
Okay. Ms. Weston Sherwood, let me just ask you, what is your mineral interest, percentage-wise, in this this well site? Do you know what percentage mineral interest you own?
I don't know what percentage. I don't have that before me. I do apologize.
Or number of acres? Do you know what number of acres?
I know it's several wells.
Okay.
I believe it's like 6 to 9 wells, something like that.
Okay.
In retrospect, I think in 9 wells. I'm not recalling.
Ms. Weston Sherwood, do you have any other motions that are pending that should be considered by this board?
Yes, I submitted some laws late last night that concern me very much. If this is the proper time to approach those concerns.
We can't address those concerns today because we haven't had enough notice to study the question. So we actually cannot consider those today. Do you have any motions other than the things that you submitted this morning?
Yes, I object to their action, and I request a lawyer, and I request a postponement until such a time as I can have help.
Okay. Mr. McDonald, do you have any closing comments
No.
on any of these motions?
We've commented enough, and I believe our brief on our motion spells out our position.
Division, do you have any closing comments on these matters?
No additional comments.
And have we properly addressed all of the motions that you submitted to this point, Ms. Sherwood?
I haven't been able to enlarge upon them, but those are the motions.
Okay.
Unconscionable law is just profound.
Okay, the board is going to need to discuss all these motions. So we are going to recess for a short time to discuss all of these. We will come back with a decision, hopefully in 15 or 20 minutes, hopefully by 20 after 10 or so. And we're going to go off record to do that. Thank you, and we will be back in just a few minutes with our decision. Thank you.
1.
The board is back in session, and we have some motions to go forward. On the first motion we heard today, do I have a motion?
Yes, on motion number 1 to convert, I make a motion to grant the petitioner's motion to convert as Ms. Weston Sherwood is a leased party and not being compulsorily pooled.
I'll second that.
All in favor, please say aye.
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 Any opposed? Motion passes. The next motion, please, that we heard.
Motion 2 to postpone. I make a motion to deny the motion by Ms. Weston Sherwood as she's not a party to today's compulsory pooling.
Do I hear?
I'll second that.
Been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Motion passes, carries.
Okay, motion 3 to appoint a lawyer. I make a motion to deny as the board has no authority to appoint lawyers under Utah law.
I'll second that motion.
All in favor, please say aye.
Aye.
Any opposed? Motion carries. That's the resolution of the motions today, Ms. Weston Sherwood. I understand you filed some paperwork today for an accounting. Our board counsel will contact you here in the future to see if this can be docketed for the August meeting. You're certainly welcome to listen to the forced pooling argument that's going to occur now, and there will be time for you to comment when they're done presenting their case if you'd like to.
Yes, I would like to.
Okay, we'd be glad to have you online. We're going to proceed now with the forced pooling matter the forced pooling matter. Thank you. Mr. McDonald.
Thank you, Madam Chair. With me today, offering testimony in this matter, and for the IT people, if you could have Mr. Kovach's visual and audio available. Thank you. With me today are Mr. Scott Osborne, who is the senior landman. He's in person here, of course, and Mr. Brett Kovach, who's the senior reservoir engineering. He's appearing virtually pursuant to your order of last Friday. At this time, I would ask that the vice chair swear in the witnesses.
Please raise your right hand. Do you swear that the evidence you're about to present is the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
I do.
Thank you.
Thank you. Members of the board, the resumes of both witnesses were collectively submitted as Exhibit 1. If separately asked, they would verify the contents of the resumes are true and correct. Mr. Kovach was previously recognized by the board last month as an expert in petroleum engineering, and presuming that the division has no objections, we ask that the board again recognize him as an expert in that discipline for purposes of this cause.
No objection.
Thank you. Mr. Osborne is testifying before the board for the first time in a capacity as a witness, and we will qualify him as an expert in petroleum land management at the commencement of his testimony. I want to confirm that you received the supplement to Exhibit 28, which was just the update on the return receipts of the mailing of the request for agency action, and also the revised Exhibit 6 yesterday, which just fixes the gross working interest of the parties in the drilling unit.
They've been received.
Thank you. And finally, I will be moving for admission of the exhibits at the end of our presentation to Chief as a whole.
Thank you.
Right. Members of the board, this cause involves the compulsory pooling for the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of Sections 13 and 24 of Township 3 South, Range 3 West in Duchesne County. The drilling unit was established by the board's order entered in cause number 139-134. A true and correct copy of the 139-134 order was submitted as Exhibit 2 in this cause. In accordance with the 139-134 order, Newfield Production Company, which was FOURPOINT's predecessor by merger, name change, and assignment, drilled the 2 Shields long lateral horizontal wells at issue in 2016. What I will refer to as the Shields 1H well traverses the east half of the sections, and the 3H well traverses the west half, east half of both sections. Both wells produced from the Uteland Butte member of the Lower Green River Formation. First production from the 1H well was on August 11, 2016, and from the 3H well was 1 day later. Previously in 2012, Newfield had drilled the Connolly well, a directionally drilled well within Section 24, pursuant to the board's order entered in cause number 13990. That well produced from the Wasatch Formation, and such production was originally allocated on a sectional basis. However, the 139-134 order modified the 13990 order to provide that production from the Connolly well would convert to the two-sectional drilling units basis, effective as of the first of the month following first production of the first long lateral horizontal well drilled. As part of that, Newfield also agreed to waive any further non-consent recoupment owed for that well as of the conversion date. Based on the production of the 1H and 3H well, the Connolly well converted as of September 1st, 2016. Notwithstanding, for some unknown reason to FOURPOINT, Newfield never sought compulsory pooling order relating to the Shields wells. FOURPOINT is before you today to remedy that and to assure proper accounting to the production interest owners is made. As alleged in the request, there were 11 parties specifically identified therein to be compulsory pooled and declared as non-consenting owners. However, subsequent to the filing of the request for agency action, Terry O'Reilly and Kevin Chatwin, two of the parties originally named, have leased to FOURPOINT. Consequently, we moved to amend the request to omit them as named parties to be compulsory pooled and declared as non-consenting owners. This is also why Exhibit 15 was intentionally omitted and not filed, and why we will not be submitting Exhibit 16 for admission into evidence today. The total amount of gross working interest to be compulsory pooled is therefore 0.143623%, as shown in revised Exhibit 6. I'd just like to confirm that the board will accept our motion to amend to omit those two parties.
So accepted.
Thank you. In addition, some of the fee leases were granted by parties claiming buy-through and under the estates of certain deceased parties, as identified in the request, for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, have not been completed to evidence proper distribution to the heirs or devisees. As such, there's the possibility of some unknown party claiming buy-through or under these estates who is unleased and not pooled. As to Diana Sue Knoll and the heirs or devisees of Patsy Cleona Coulter, and as to other such potential unknown heirs or successors that I just mentioned, pursuant to the June 17, 2025 ex parte order of the board, notice to such parties was published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to that notice or otherwise tendered his or her share cost of the Shields wells. FOURPOINT also therefore seeks to have these parties declared as compulsory pooled and non-consenting owners. The proof of publication of the notice of opportunity to participate was submitted as replacement Exhibit 22. As to the non-consenting owners, FOURPOINT seeks imposition of a 300% risk compensation award and the terms of a joint operating agreement materially the same as signed by the other working interest owners in the drilling unit, in which terms have been previously deemed just and reasonable by the board in other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners will be entitled to a 17.071829% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of spud of each of this Shields wells. The board has jurisdiction over this matter pursuant to Utah Code Section 40-6-6.5 and the implementing regulations at R649-2-8A and R649-2-9A. Copies of the request were mailed certified mail, return receipt requested, to the parties to be compulsory pooled, and via regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records, to the Utah Division of Forestry, Fire, and State Lands due to the state-acquired lands that are under the Division of Wildlife Resource jurisdiction, and they also own the minerals, and also to the Bureau of Indian Affairs due to the allotted mineral ownership within the drilling unit. In addition to the published notice of opportunity to participate in the Uinta Basin Standard previously mentioned, notice of the filing of the request for agency action and of the hearing thereon was also duly published in the Uinta Basin Standard on July 2nd and in the Salt Lake Tribune on July 6th. On July 10th, 2025, the Utah Division of Oil, Gas, and Mining filed a response expressing its non-opposition to the granting of the request, presuming FOURPOINT meets its burden of proof at this hearing, which we will do. As you are aware, Ms. Alice Weston Sherwood, a least voluntarily pooled mineral interest owner, did file an objection, but based on the board's motions, rulings this morning, she will be offering public comment only. And again, we ask that we have an opportunity to rebut any public comment made at that time in FOURPOINT's defense. No other objections or responses to the request by the non-consenting owners were timely filed, and none have made an appearance today. As none of the alleged compulsory pooled and non-consenting parties filed a timely response, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, we move forward to enter an order of default against them and ask that the board rule on that motion at this time.
Division, do you have any comments?
Yeah, no objections.
Board? So accepted.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Osborne. Mr. Osborne, would you please state your name and business address for the record?
Scott Osborne. I work for FOURPOINT Resources at 100 St. Paul, Suite 400, Denver, Colorado, 80206.
And what's your current position with FOURPOINT, and how does it relate to the drilling unit at issue?
I'm a senior landman with the responsibility over this drilling unit amongst many others in the basin.
All right, Mr. Osborne, since this is your first time testifying, would you please provide to the board a very brief summary of your education and work experience, particularly in the Uinta Basin or another analogous basin with horizontal well development, and particularly with any joint operating agreement preparation and negotiation?
Sure. Graduated from Texas Christian University in 2003 with a business degree. Started working for Sanguine Gas Exploration in 2004, working Western Oklahoma, Texas Panhandle. Then went and worked at Chesapeake for 18 months, and then went over to FOURPOINT, where I continued to work Western Oklahoma, Texas Panhandle for 6 years. And then just recently, after acquisition of Ovintiv's position, I've been working this basin.
All right. Do you have any memberships in industry-rated land professional groups?
Yes, I'm a member of the AAPL, the Oklahoma City Association of Professional Landmen, the Tulsa Association of Professional Landmen, the Denver and the Utah Association of Professional Landmen.
All right, with that, in his resume, and we would ask that the board recognize Mr. Osborne, an expert in petroleum land management.
Division, do you have comments?
The division reviewed Mr. Osborne's resume and we're in agreement.
Board, do you have comments? So accepted.
Thank you, Madam Chair. Mr. Osborne, would you state for the record, please, the corporate and bonding status of FOURPOINT?
FOURPOINT is a Delaware limited liability company with its principal place of business in Denver, Colorado. It is the successor by assignment to Ovintiv USA, Inc., successor by name change and merger to Newfield Production Company. FOURPOINT is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all relevant federal and state of Utah agencies.
Mr. Osborne, I'm now going to show you what have been marked as Exhibits 3 through revised Exhibit 6. They're shown on the PowerPoint here. Do you recognize these exhibits?
Yes.
Were they prepared by you or FOURPOINT personnel with your review and input?
Yes.
Okay, turning your attention to Exhibit 3, would you please explain to the board and the division what this shows?
This is a map showing the drilling unit is located approximately 2 miles due east of the Arcadia town site and 3 miles north of US 40 in Duchesne County.
Now, turning your attention to Exhibit 4, please explain what this shows and its significance to today's hearing.
This is a plat that shows the wellbores across the DSU. The green is Indian allotted acreage, orange is the state, and yellow is fee acreage. As you can see on there, the Connolly well was directionally drilled in 2012 and produces from the Wasatch Formation. The productive intervals in the northwest, southeast of Section 24. Production was allocated on a sectional basis pursuant to Order 139-90 until conversion as provided in the 139-134 order. Conversion occurred effective September 1st, 2016. Any remaining non-consent recoupment then due was waived. The Shields 15-12, 3-3-13-24 1H was spud on May 24th, 2016 and completed as a producing well with the productive intervals in the east half of both sections. and in the Utland Butte member of the Spaced Formations. Its date of first production was August 11th, 2016. There's also the Shields 15-12, 3-3-13-24 3H. This well was spud on May 21st, 2016, and was completed as a producing oil well with a productive interval in the west half, east half of both sections, and in the Utland Butte member of the Spaced Formations. Its date of first production was August 12th, 2016.
What's the payout status, do you know, of the Shields wells?
Information was very limited in what we received from Ovintiv. We know that both wells have reached 100% payout, but they have not reached the 300% payout.
Okay, now turning your attention to Exhibit 5, would you please explain what this shows and its significance to today's hearing?
Exhibit 5 is the mineral ownership tracts in the DSU. The DSU is 1,280 acres with 20 different ownership tracts. Tracts 1 through 4 and 13 through 20 are allotted Indian tracts. Tract 7 is state-owned tract. The remaining tracts owned are in fee. Ms. Sherwood Weston's interest is in Tract 6, through which the 1H well traverses through that tract.
All right, and just as a reminder, the board has provided in the statute, royalty under the allotted and state leases are not included in the average weighted fee royalty calculation. Mr. Osborne, now turning your attention to revised Exhibit 6, would you please explain what this shows and its significance to today's hearing?
This is the DSU working interest ownership summary. FOURPOINT is a majority lessee working interest owner in the DSU and is the operator of the Shields wells. Additionally, lessees working interest owners in the DSU are Silver Eagle Refining, Woods Cross Inc., Gary Griffiths, Wayne Griffiths. All have signed JOAs with FOURPOINT, the terms of which contractually govern well elections, including the elections made on the Shields wells. The total gross working interest to be compulsory pooled is 0.143623%. Newfield has executed and recorded a pooling declaration pooling its fee leases pursuant to the authorization contained in the various pooling clauses of the leases, and secured a communization agreement communitizing the allotted leases with the fee leases.
All right, Mr. Osborne, I'm now going to refer to Exhibits 7 through 14 and 17 through 20. These are paper documents, so we're not going to do a PowerPoint on these. Do you recognize all these documents?
Yes.
And are they official business records of FOURPOINT?
Yes.
All right, would you please explain what Exhibits 7 through 14 are and 17 through 21?
These are notices of opportunity to lease and or participate sent to the following parties. Alfred M. Fairbanks, who owns 0.137513 gross working interest in the DSU. Belinda K. McCarty, who owns a 0.000271% gross working interest in the DSU. Diana Sue Knoll, who owns a 0.000271% gross working interest in the DSU. Frederick Kent Smith, who owns 0.001221% gross working interest in the DSU. Jane Martindale, also known as Janice Marie Atkinson, owns a 0.001627% gross working interest. Owen Robert Bergner, who owns a 0.001627% gross working interest. Richard Muir, who owns a 0.000116% gross working interest in the DSU. Robert Reed, who owns a 0.000163% gross working interest, along with proofs of receipt as to Ms. Knoll, proof of attempted delivery but unclaimed.
Did anybody respond to those notices?
No.
All right. Are there any other parties that were being compulsory pooled here?
In addition, Patsy Cleona Coulter owns of record a 0.0000814% gross working interest in the DSU, but she is deceased, and despite diligent efforts, FOURPOINT has not been able to identify her successors.
All right. What about other parties, known or unknown parties?
In addition, as Mr. McDonald mentioned, several lessors claim title in these lands through one or more of the estates of the deceased record mineral interest owners identified in the RAA. In the interest of brevity, we ask the board take administrative notice of the deceased parties. Either no Utah probate of the estates have been identified, or if filed, they're incomplete and that there has been no proper distribution made to the heirs or devisees.
Okay, what about the efforts that FOURPOINT made to identify those parties, and are they successors? Did they lease or did they not?
Although based on the ownership affidavits and the other inquiries, research done by FOURPOINT's lease broker, FOURPOINT believes it is it or the other voluntarily pooled working interest owners have leased all of the successors. However, without an order from a Utah court confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore FOURPOINT seeks to compulsorily pool the interest and declare them non-consenting owners.
I'm going to refer you now to Replacement Exhibit 22. Is this an official business record of FOURPOINT?
Yes.
And what is this document?
This is the proof of publication of the notice of opportunity to participate to Ms. Knoll, the heirs or devisees of Patsy Cleona Coulter, the unknown heirs or devisees of the decedents just mentioned.
Did you ever receive any responses to the published notice?
No.
All right. Now turning your attention to Exhibit 21. This was also filed as Exhibit A to the request for agency action. Do you recognize these documents?
Yes.
Was it prepared by you?
Yes.
All right. Please explain what it represents.
Form utilized is a standard industry form supplied by the American Association of Professional Landmen, Form 610. This is the 1989 version with modifications to address horizontal wells. It's materially the same JOA sent to the mailed notices of opportunity as just outlined. The terms and conditions contained therein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units, including the JOA signed by the other voluntarily pooled working interest owners in the DSU. Ovena before and FOURPOINT is now preparing identical forms for other drilling units they operate, and they have agreed to, subject to such terms and other drilling units in which we do not operate, including drilling units operated by UNIWAX, Crescent Energy, and other major Uinta Basin operators.
All right. Turning your attention to page 7 of the main portion of the joint of operating agreement. What's that provision there?
These are the non-consent penalties, which is 100% and 300% as provided, same as contained in the JOA signed by Silver Eagle and the other parties.
All right. Now turning your attention to Exhibit C of the joint operating agreement. Get to that real quick. Okay, can you point out the salient, what is this document and the salient provisions relevant to the compulsory pooling?
This is the COPUS accounting procedure. Again, standard industry form, almost universally utilized, similar to the other JOAs in the basin. Page C3, Article 3B, sets the interest rate at the prime rate as published in the Wall Street Journal plus 3% as fair compensation to encourage timely payment of chargeable costs and expenses. And page C9 outlines the overhead charges of $10,090 and $1,090.
All right, is it your expert opinion then that the terms and conditions of the proposed joint operating agreement are fair and reasonable and consistent with those accepted by the other working interest owners in the drilling unit, and with
Yes.
those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes.
All right. With respect to these unknown heirs or owners or successors to the decedents, will you modify the Exhibit A if and when they're identified and what their interest may be?
Yes.
All right, thank you. All right, now turning to what has been marked as Exhibit 23, I'm going to just go to the last page of this. Do you recognize this document?
Yes.
Was it prepared by you?
Yes.
And what does this represent?
Reflects calculation of the average weighted fee landowner's royalty for the DSU as of the date of spud of each of the Shields wells. The average weighted fee royalty is 17.071829%. This differs from what was previously filed because I inadvertently had included royalty from leases that were taken after the well spud.
All right, but this is, you're confident this is the average weighted as of the date of spud?
Yes.
All right. Now I'm going to show you what has been the certificate of service. This was a pleading prepared by my office and already on file in this cause. Do you recognize the names and addresses shown here?
Yes.
And who are those parties?
Purchase shown are all the production interest owners within the DSU. Addresses derived from title opinions effective as of November 8th, 2011 as to Section 24, and October 27th, 2018 as to Section 13, and as updated by search of the county records by Lone Wolf and FOURPOINT internal records.
And Lone Wolf is your contractual lease broker?
Yes.
Okay. And for the board, again, Exhibit 28 as supplemented reflects the receipts of the certified mailings of a copy of the request or the status of the mailings for which no return receipt was received back by my office. With that, that concludes my examination of Mr. Osborne.
Division?
Thank you. Could I get a clarification? Could you go back to revised Exhibit 6, please?
Whoop, sorry.
So these numbers were revised, and I'm just looking, I guess, specifically at the compulsory pooled interest. We indicated that 2 parties have subsequently leased. However, the compulsory pooled interest number went up. Do you have an explanation for that?
Yes. So, as I previously mentioned, I'm working on a lot of information that is passed from Newfield to Oventive to us. Some of the information that was originally provided from Oventive to us was incorrect, and I've had to go back through, revise all my numbers, rerun everything. So unfortunately, it was an error that I'll take responsible for that was not caught before it was originally filed.
Okay, so this number here, that's as far as you know right now.
That's correct.
Okay, thank you for that clarification. Just a couple questions, and you may or may not have answers to this based on when FOURPOINT obtained this asset. So these wells were drilled in 2016. Here we are in 2025. Are you aware of any attempt that the prior operator made to allow these parties to participate at the time of the drilling of these wells?
Once again, the information I'm provided is very limited. I do know that Oventive had sent out the NOPs when they started this action, but other than that, I'm very limited in what information I have.
Okay, thank you. Another question indicated in the RAA and in your testimony today, you talk about that information is limited. We have a request today for a 300% non-consent penalty. How are you able to tell when these wells will pay out 300%?
So we were provided some payout decks, and based on the numbers on the payout decks, it's very obvious that they are still calculating the 300% because there's just, it would have hit it by now. And from what I've been told I'm not an accounting expert, but what I've been told is that the accounting has determined that it's still within the 300% payout period.
Okay, but you will have, FOURPOINT does have a number that they will know when 300% is hit. Okay.
Yes.
All right, thank you. All right, thank you. No further questions from the division.
Board, do you have any questions for this witness? Mr. Church?
Just to clarify, although it's still in the non-payout, royalty interests are being paid
Yes.
to all parties except for the non-pooled interest. Those that are compulsory pooled to date will then start receiving royalty interest. Is that correct?
Yes, sir.
Okay, thank you.
Let me just clarify that Ms. Weston Sherwood's interest is not any of these compulsory pooled interests today.
That's correct, and Mr. Osborne can address whether she's in pay status or not at this point.
If you could do that, please, I'd appreciate it.
Yes, ma'am. She is currently in pay status. Her interest, her royalty payments have not been distributed yet because she has not met the minimum $100 payment. So when I verified last week, she was at $66 and change, and as of yesterday, they did a check run. She is now at $99, so she should receive a payment next month.
Thank you. Moving on.
Thank you, Madam Chair. With that, I'll commence my examination, Mr. Kovac. Again, if the IT people could have his visual and audio up, please. Thank you. Mr. Kovac, would you please again state your name and business address for the record?
Yes, my name is Brett Kovac, and business address is 400 St. Paul, Denver, Colorado.
And what's your current position with FOURPOINT, and how does it relate to this drilling unit?
I'm a senior reservoir engineer, and I'm a senior reservoir engineer that works on this part of the field for FOURPOINT Resources.
All right, Mr. Kovach, hopefully you have these exhibits in front of you. Otherwise, they're showing up on the PowerPoint presentation. Exhibits 24 through 27. Do you recognize these exhibits?
Yes.
And were they prepared by you or FOURPOINT personnel with your review and input?
Yes.
All right, turning to exhibits 24 and 25. I've got 24 up. Would you please explain what these show?
Yes, this is the estimated well cost for the Shield 313 24 1H, and then the subsequent exhibit is for the Shields 15 12 33 13 24 3H.
All right, and how do these costs, these are estimated costs. Do you want to explain that a little bit?
Yes, so these are estimated drilling completions. You can kind of see we have it broken out into a couple different rows there. So the drilling completions and production costs, those are coming from our field estimated costs from WellView. And just for reference, WellView is the software that Ovintiv was using to report daily costs incurred during the operation of drilling and completing the well. So we do believe that those should be reflective of the costs of the operations for the wells. And then for the facilities costs, given that we don't have that actual cost from Ovintiv, what we're using for that is the facility cost, the average facility cost from 2023 and 2024.
All right, and how do the total that you show on these exhibits relate to the AFEs that were sent out for these wells?
These total capital costs come in below the AFEs that were sent out.
All right, in your expert opinion, were these costs fair and reasonably and necessarily incurred?
Yes.
And based on your review of this, were the wells deemed economically feasible, as that term is used in the 139, 134 order to drill?
Yes.
All right, would you please explain to the board what FOURPOINT's estimated plugging and abandonment costs are for the two Shields wells?
Yes, our estimated plugging and abandonment cost is $90,000.
And that's higher than what Ovintiv had asked in previous ones. I believe they asked for $75,000. Can you explain why the difference is?
Yes, so we are not 100% sure how Ovintiv came to their $75,000 number, but upon our team's review, we believe that $90,000 was an appropriate number for the abandonment of these wells.
All right, and just for the board's information, I included the $75,000 in the request for agency action based on what I thought they were carrying forward Ovintiv. So Mr. Kovach is explaining now that the FOURPOINT position is higher at $90,000. All right, turning your attention now to Exhibit 26. Would you please explain what this shows and its significance to today's hearing?
Yes, so here we can see in the green outline there, that is the two Shields wells in the eastern half of the DSU. And so one of the things that we can notice here is that at the time that the Shields well came on, these are all the wells that were in the existing area at that time. And so there are really very few 2-mile laterals that have been drilled in the area. So a couple things to note, there were no 2-mile laterals in the Uteland Butte that existed to the south that were modern completions. And those McKinnon wells that we have referenced are to the west, are roughly 2 to 3 miles away. So a couple notes on those McKinnon wells. The McKinnon wells were spud in March and in May of 2016, with their first production coming online in June 2016. And the Shields wells, the wells we're talking about today, were spud in May and June 2016. So although the McKinnon wells were technically online at the time of the Shields spud, there really wasn't any actual production history to assess the true productivity of a modern Uteland Butte well in this area. And so the Shields wells, for all intents and purposes, were really step-out wells with limited analog data and some high geological uncertainty at the time of spud.
All right, now turning your attention to Exhibit 27, would you please explain what this shows and kind of outline what it represents?
Yes, so this is a list of the pre-spud risks that come with really any modern horizontal well in the Uinta Basin. I know that we've shown these before to the board as well, so I know these will not be, totally new to everybody, but just a couple to call out here, especially given that there were, not many 2-mile horizontal wells drilled in this area at the time. There was definitely a risk of the drilling conditions and the geological risk of how the well was going to perform, particularly the reservoir fluid properties, given the lack of well control. Now, one thing to note is that, although there are always risks prior to drilling, in this particular case, we do not believe that these wells had any significant issues as evidenced by the Shields wells coming in under the AFE costs that they were kind of sent out at by, I believe it was Newfield at the time. And so, yeah, we feel like these are representative risks of drilling in the area, but the Shields wells did not have significant problems.
Right. Is it your expert opinion then for these reasons that a 300% risk assessment award is justified in this matter?
Yes.
Right. Thank you. That concludes my examination, Mr. Kovach.
Division.
Thank you. Could I ask that we go back to, let's do Exhibit 24. That'll work. Mr. Kovach, you indicated that these were estimated well costs. I assume, again, that's because you do not have the actual records of actual costs?
Yes, these are estimates from the field, which we do believe should be very representative of the well costs.
Okay, so are these numbers then estimates as of the cost of 2016, as of the time of drilling?
Yes, so this was the total cost of the drilling, completion, and production of the wells.
Okay.
Production costs, so kind of the tubing and the equipping and everything.
Okay, as of 2016.
Yes.
So then facilities, could you explain the facilities number then to me, please? You indicate that costs for 23, 24. How do these relate back to 2016 forward?
Yes, so in the well view reports, we didn't see a specific breakout for the facilities costs. And so what we looked at for the facility costs, given what we had seen from Oventive most recently, was kind of our average estimate for 23, 24 based on what their actual costs were for those years. And so the reason we went with that was, generally, I would say costs usually come down over time. So that should be a conservative number to use.
Okay, thank you. And then with that in mind then, because these are estimates, could you explain the difference between the Shield 1H, which has a drilling of roughly 2.5 million, and the Shield 3H on the next exhibit, which is a little over 5 million? Why were those estimates different? Sorry, why were those estimates different?
Yeah, so it looks like the big difference came on the drilling cost side. So my understanding is most likely, I'm gonna have to go back and read through every single one of the daily reports to make sure, but my understanding would be that it would probably have been a longer drill time for that, the 3H well versus the 1H well.
Okay, thank you. And just to clarify then, in your expert opinion, these costs do reflect the actual costs of 2016?
Yes.
All right. Thank you. No further questions from the division.
Board, do you have questions? Mr. Walker?
Yeah, following up on Mr. Haynes' question on the difference between the 1H and the 3H. And I don't want you to go back through every drilling record for the day, but do you have that from your recollections? And I know it's two owners before that actually did the drilling, but anything further than it was more days? I mean, there's got to be a reason they were spud just a day or two apart and something went wrong.
Yeah, without going back through and kind of filtering through it, I think it'd be hard to give kind of the exact reason. But that kind of the 3H was pretty close to the AFE number that was provided, and still was a little bit under. So I think really both of these would most likely be considered operational successes for them at the time. Though I'm not entirely positive what the difference is between the two wells.
Okay, thank you so much. Bye.
Moving on.
Thank you, Madam Chair. With that concludes our presentation in chief. At this time, I would move for admission of Exhibits 1 through 5, Revised Exhibit 6, Exhibits 7 through 14, Exhibits 17 through 21, Replacement Exhibit 22, Exhibits 23 through 27, and Exhibit 28 as supplemented. And I'm going to reserve the right to also admit the rebuttal exhibits depending upon the public comment provided by Ms. Weston Sherwood.
So admitted.
Any objection from the division?
No objection to
All right, thank
admitting
you.
the exhibits.
And with that, I'll reserve my closing comments after the public comment.
Let's see, I guess we're going to move back to Ms. Weston Sherwood. Do you have any follow-up comments? Are you,
Yes,
I think,
do. Thank
there we go. Please go, yeah, please go ahead.
Yes, if I was ever pulled, it was not to my consent, and I do argue that FOURPOINT's action is an abuse to these 40 family and myself, and that we've trusted to the company to protect our interests. And instead, they have abused and usurped our interests and systematically reduced our interests, lessened owner rights in general, lessened pay unjustly required, and added other costs like 300% and other costs and well costs, and it just from owners unjustly, and usurping these 9 years pay back to 2016. When the company costs should come from the company, and instead this company covers up those instead of making it right to my family. And I contend that FOURPOINT is an aggravated violation of Utah unconscionable law, which is a legal doctrine. I to send it here to you. That describes terms that are extremely unjust or unfair in an agreement. Generally, it applies when one party has superior bargaining power over the other, one party is experienced in a matter, and the other is an average consumer, and the resulting agreement is extremely one-sided. This is Sosa versus Paulos 924P2D 357 360 Utah 1996 law. And I do submit that the company changes contracts throughout years to their advantage, and owners do not have the same power. And this is a gross unlawful imbalance of power in violation of Utah unconscionable law, and that owners should be able to reverse such actions as today if there is a justice of power between our leases. And I do submit that the company is in gross violation of this law, and that as owners, we should not have our ownerships reduced in such a matter when all 40 of my relatives today and myself have been trusting this company to uphold and our interests, and instead they have systematically reduced our interests. And I do submit most strongly that this is an evil violation of justice, and that our family should have the ability to turn such laws back around if we should apply to the board as well.
Thank you for your comments. If you are to speak for anyone other than your personal interest, we would need to have the named parties and their interests, just for future reference. Right now, we can only look at your interest in the things that we have talked about today. Mr. McDonald, would you like to rebut her comments?
No, I believe our motion speaks to those issues. Again, if she believes there's been a breach of the contract, the lease, then her remedies are with a court. It's not in front of the board here. We would dispute that FOURPOINT is in breach. We would dispute that FOURPOINT has not acted in good faith. There's no record necessarily of the contact that she says that FOURPOINT has lacked. The payment, I believe Mr. Osborne's testimony reflects that the reason she hasn't been paid for this year is because the revenue from all of her wells has not reached the $100 mark as provided in Utah Code Annotated 40-6-9. She should receive a check next month. So with that, that's the only thing we need to do. I believe the board's already accounted for Ms. Weston Sherwood's comments. Thank you.
Thank you. Do we have any division comments?
Would you like us just to give our closing comment?
Yes, please.
Sure. Thank you. The division reviewed Four Point's request, reviewed their RAA and their exhibits, and after listening to the testimony here today, the division, as it indicated in its response, is not in opposition of this request.
Thank you. Board, do you have any closing comments or questions? Seeing none, are we prepared to vote, or do we need to deliberate on this matter?
Ma'am?
Yes.
Yes, 4 Points is misinterpreting my complaint. It's not of pay. My complaint is of their ability to change laws and alter and reduce our owner rights without our ability to do the same and rescind and redo those. It's an imbalance of power that is unjust, of which I'm complaining.
Thank you for your comments. Board, are we prepared to make a motion, or would we like to deliberate? I think we can. Okay. We're going to take a break for about 10 minutes until 11:25. We will be back.
1.
We are back on record, and I think we are ready to propose a motion. Do I have a motion?
I'll make the motion that we approve the request for agency action as presented.
A second? It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Motion carries. Mr. McDonald, if you would prepare the order.
Certainly, and I'll make sure that Mr. Haynes gets a copy of it, and Mr. White to add in their comments. I'd also like to thank the board particularly for the accommodation for Mr. Kovac. He had a baby last week.
Oh, my
And
goodness.
so other than losing sleep, everybody's doing fine. So thank you very much for your accommodation.
Thank you. Appreciate it. We are going to move on to docket number 2. We'll try to conclude this, and then we will probably break for lunch before we go on to item 3. As you're getting set up, Mr. Walker has a disclosure.
Yeah, I need to disclose that my deceased mother-in-law had or potentially has an interest in the Collins well, which will be inherited potentially by my wife, and it amounts to somewhere in the order of about $50 a month, from what we understand at this point in time. But I don't see an interest in my recusing myself.
We've lost our attorney.
We just have blank screens on our side, so see if we can get some IT help.
There we go.
He's back.
Does the petitioner object to Mr. Walker participating in this hearing?
No, the petitioner does not object.
Thank you. Board?
No objection by the
Okay.
division.
Division. I know where I am. Mr. Chicken, shall we begin?
We shall. Do you want to read
hang on.
the
Yes,
caption?
I want to read this into the docket first. Docket number 2025-025, cause number 134-02. In the matter of the request for agency action of U.S.M Operating LLC for an order authorize the flaring of gas in excess of the amounts allowed under Utah Administrative Code Rule R649-3-20 from the Black Buck. I'm just going to read the names here. The Black Buck well in the southwest northwest section 32, 4 south, 4 west, U.S.M. The Bongo well in the southwest northwest section 32, 4 south, 4 west, U.S.M. The Collins well in the northeast northeast section 25, 4 south, 4 west, U.S.M. The Gemsbach well with a surface location in the southwest northwest 32, 4 south, 4 west. The Lee well in the northeast northeast section 25, 4 south, 4 west, U.S.M. And the Nelgai well in the southwest northwest 32, 4 south, 4 west, U.S.M., all in Duchesne County, Utah. Mr. Chicken, appearance of counsel.
Brent Chicken, Steptoe and Johnson, PLLC, on behalf of W.M Operating LLC.
Okay.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Back to you, Mr. Chicken.
I'll give a brief summary here and then turn it over to my one witness. The first order of business is to inform Madam Chair that that is the last time you are going to have to read that caption.
Yeah.
We have exceptional news and this cause number 13402 today. As the board is aware, this matter was first heard by the board in March. An order was entered granting a flaring exception for these 6 wells through May. We appeared at the board in May and received an extension of that order that would continue the gas flaring from these wells, which are from the Lee and the Goat pads, through September 24th, 2025. But we're happy to announce today that we've had great developments with these wells. But I'm going to let my client tell you all about that. And so I have one witness today, Mr. Dustin Shrike, sitting to my left. He is the Chief Operating Officer and engineer for W.M Operating. He has been admitted before this board in the past as an expert in petroleum engineering. And so subject to him being sworn in and any voir dire from the board, I would like to offer his testimony today as expert testimony in petroleum engineering.
Do you have any objections, Division?
Nope.
Board, do you have any objections? Could we proceed with swearing him in?
And please raise your right hand. Do you swear that the evidence you're about to present is the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
I'm going to go to, these exhibits were demonstrative in nature only, so they will not be being admitted into the record. They don't need to be. I'm going to go to our first exhibit, which is Exhibit A, and Mr. Trike, tell the board the good news.
Well, good morning. We've been looking at this chart for the last 5 months or so. So fortunately, you can see the bottom right of the chart where you see our bright red line that's indicated our flared gas volumes over that period of time. With these two pads in particular, at one point we were flaring 6 million a day. We successfully have dropped that to 0 as of about 2 weeks ago. So mid-July, we were able to get all of the gas captured off of our Goat and Lee pads, pulled off the flare symbols you see in the top left locator map, and overall just super pleased that we made progress here before our September deadline, and we've put this one in the rearview mirror officially.
Thank you.
Sorry, I have one more exhibit, Exhibit B. And this just shows the general timeline for the Lee and the Goat pads. I think testimony on this has been admitted, but in previous hearings, but I didn't know if Mr. Trike wanted to say anything about this exhibit.
Really simple exhibit, just a basic timeline. So the left side is 2024 in the lighter blue, and then on the right side in the darker blue is 2025. So a year ago, as we were closing on the acreage acquisition, we had a 1-rig program. We drilled 3 pads all back to back. That was Lee, Goat, and Bridgeland 4. Early in 2025, we realized we have a pretty bad gas problem in terms of flare gas. You could see we got Lee off of flare in May and then Goat off of flare in July. So appreciate the patience and working with us through that period of time. And yeah, you'll see this slide again in our next docket item.
I have no further questions for Mr. Trike.
Division, do you have any comments?
No, we don't have any specific questions for Mr. Trike, but we applaud WEM's efforts, and it's great news. Thank you.
I'd like to just compliment you on how quickly you've gotten these wells put into production. Big lift, and you've done a good job, so good deal.
Thank you.
All right.
Can you remind us which of these, the 5 wells we're talking about today, which ones are on Lee and which ones are on Goat?
So the Lee pad is Lee and Collins, only 2 wells there, and then our Goat pad is all the antelope species. So you have the bongo, blackbuck, nilgai, and gemsbok.
Okay, gotcha. Thank you. Okay. Thank you.
All right. If there are no further questions, I think we can retire this issue. And you're done coming back to us on this matter.
Yes, Madam Chair, we are. And depending on what the board wants to do, we're prepared to proceed on 13403, either now or after. My only comment on this would be, depending on what the board's timing is like with the rulemaking matters this afternoon, we're happy to do it now. We're happy to do it after lunch, but you can see the Bridgeland 4 pad in this. And as the board is well aware, we are talking about the same exact areas here. We're talking about the same gas capture systems and infrastructure. And we're just now talking solely in 13403 about the 4 wells on the Bridgeland pad that were the subject of the emergency order that's currently in place through today.
How long do you think your presentation will be?
30 to 40 minutes. Maybe we have 3 witnesses. I have Daniel Gunnell, the CEO of WEM, Mr. Trike, and Mr. Williams, the Senior VP of Land.
I hate to break in the middle of a hearing, so I'm thinking we'll proceed with this matter and then we'll break for lunch. Is that all right with the board to do that? Okay, let's move on to docket item number 3. Docket number 2025-041, cause number 134-03. In the matter of the request for agency action of WEM Operating LLC for an emergency order authorizing the flaring of gas in excess of the amounts allowed under Utah Administrative Code 649-3-20 from the Arabian 44-4-18-17-7H well, the Walker 4-4-7-8-1H well, and the Shire 4-5-12-11-2H well, and the Clydesdale 4-5-13-14-8H well, all with a surface location in Lot 1, Section 18, 4 South, 4 West, U.S.M, Duchesne County, Utah. Mr. Chicken, please proceed.
Brent Chicken on Steptoe and Johnson, PLLC, on behalf of petitioner WEM Operating. Again, I won't belabor what the board already knows. These 4 wells are on the Bridgeland 4 pad. They are in the same general area as the 13402 Goat and Lee pad wells. The board entered an emergency order on June 23rd regarding the flaring of gas in excess of the amounts allowed under Utah rules. WM appeared at the June 2025 hearing before the board, and the board agreed to extend that emergency order through today. And during that period of time, this RAA that we are talking about right now was pending. This RAA will ask for a flaring exception for those same 4 wells that are subject to the emergency order that Madam Chair just read through the same date of September 24th, 2025. That was the date from the Goat and Lee pad wells under 13402. As I noted, I will have 3 witnesses today: Daniel Gunnell, the Chief Executive Officer of WEM Operating, Larry Williams, the Vice President of Land for WEM Operating, and Dustin Trike, the Chief Operating Officer. I would ask that those witnesses be sworn in.
Please raise your right hands. Do you swear the evidence you're about to produce is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes. Yes.
Thank you.
I will also note that a response was filed by the division in this matter regarding the relief sought in 13403. And we look forward to hopefully providing a presentation and some information to the division that will show them that we are, just as we beat our deadline, if you will, by 2 months on the other wells, we are working very hard to beat that same deadline with these remaining 4 wells. And indeed, I believe we'll be asked, we may be even asking for less per month per well flaring MCF authority than was actually asked for in the RAA, which was filed just about a month and a half ago on June 10th. So I will move on to my first witness, Mr. Daniel Gunnell, who is sitting to my left. Mr. Gunnell, can you please state your full name and your title with WEM for the record?
Yep. Daniel. Can you hear me? Okay. Yeah. Daniel Reed Gunnell. I'm the founder and CEO of WEM.
And your experience in the oil and gas industry is primarily as founder of WEM, is that correct?
Yes.
And you have submitted a resume of that educational and business experience as part of the exhibits for this cause number today, correct?
Yes.
I am not seeking to qualify Mr. Gunnell as an expert witness. He's a fact witness only, but I wanted to give the board and the division an opportunity to voir dire and or object to any of his history and qualifications.
Division, do you have any objections?
It's just a fact witness?
Yes.
Is that correct? Yeah, we have no comment on that.
Please proceed.
Our first exhibit is Exhibit A. And the reason for Mr. Gunnell's presence here today is we wanted to bring some of our top folks from the petitioner here to provide a little bit of a more umbrella kind of picture of where WEM came from and what it has done in the basin and what it is planning to stick around and continue to do. So I will ask Mr. Gunnell to please describe the factual items that are discussed or that are set forth on Exhibit A, and to kind of give the board a general background, history, and forward look on WM's operations in the Uinta Basin.
Yeah, thank you. And thank you, Madam Chair and Board, for the opportunity. I've worked Utah for the majority of my career in various parts, and even know Levon going back to the days when we were forming federal exploratory units. And so I was born in Utah, live here, plan to die here, and this is where we've built our company. WEM, I call WEM Utah's home team, our Utah's oil company. We're from here. We've got our headquarters are in Provo. We've got about 25 people in Provo, and then our field office out in Roosevelt also has about 25 people. And we are primarily backed by Utah investors. And we've seen lots of outsiders come and go, and it's interesting. We jumped into the Uinta Basin in 2018. And since then, we've seen Axia, then XCL, now it's SM. We've seen Newfield, then Oventive, and now it's FOURPOINT. And I just point that out because we're here the whole time. Everybody has pretty much changed, and we're still here, and we're going to be here for a long time. In the last kind of 7 years, we've deployed over $900 million into the Uinta Basin. So we're really serious about it. This map that you have in front of you shows what the Uinta Basin looks like currently. All those green sticks you see are the existing horizontal wells. I'll use this map to tell a little bit of the WEM story. In 2018, when we started in the basin, only the middle part of that had wells, and there weren't that many of them. And we started leasing in 2020 down in 4 South, that bottom area. We did a JV with Oventive, and we expanded the productive footprint of the basin by several miles to the south. So those wells, you can see where the cursor is, that we drilled 19 wells there with Oventive in 2020 and expanded the basin. The next year, we did another project up to the north with Altamont, and we did another one with XCL. Those 2 projects, we drilled the 10 northernmost wells drilled in the basin. You can kind of see the 3 up there at the top. Those were part of that program. The other thing that we did with XCL is not only did we expand the footprint, but we also funded the first tests that were done in the Douglas Creek and what they call the upper cube. So we proved up those additional zones. And then in 2023, we came down and we went further south again. We drilled a 21 well program again, extending further south in the GMBU. And then finally, you can see where the blue box is. That's what we're working on now. That's our WEM 5. So I think the thing that I wanted to point out is that WEM has had a really big part in improving up the basin and expanding the productive and economic area of the basin. This area where we are now, where we're drilling, in the past 2 years, we've spent $280 million drilling, and also of that 280, we've put $50 million into the infrastructure into the pipelines and the gas takeaway. We did have a plan, and as you've heard, some of those things didn't quite materialize the way that they were supposed to, but we don't want to flare at all, and we are sprinting to take care of these problems with the flaring. I think the other things that I would just add is that our production base, as you can read there, has been collateralized to support the long-term development. We've got over 100 future drilling locations. We are supplying crude to all 5 of the Utah refineries, and we're fully committed to getting all the rest of our infrastructure built and in place as quickly as possible. So I think that's kind of, the story that I wanted to tell. We are planning to continue to grow, and we're really grateful that Utah is such a great place to do business, and grateful for the amazing resources that we have here.
Thank you, Mr. Gunnell. That was very, very interesting to see how you've grown in just these few years.
Thank you.
Good Utah success story.
Well, thank you.
Indeed.
Mr. Chicken.
I don't have any other further questions for Mr. Gunnell, but unless the board or the division do.
Board, do you have any questions?
Yes. Of your 100 drilling locations that you have identified so far, how many are going to be horizontal, roughly?
All of them.
Okay. And how many in the upper cube?
We are drilling now our first. We are actually should be finishing drilling today our Douglas Creek test. So we'll be bringing that online in Q4, and we've also got a Long Point test. So we've got 2 in this area, this southwestern area. We're just doing our first 2 tests of those upper zones, and so how many we drill in the future will be based on results. Yeah.
Okay. Thank you.
Seeing no other questions, let's proceed. Thank you.
My second witness is Larry Williams, Vice President Land for W.E.M. Operating. Can you please state your full name and title for the record?
Larry Williams. I am the Vice President of Land for WEM, for the WEM entities.
I would be offering Mr. Williams' testimony today as fact testimony. However, if the Board of the Division did want to ask an opinion question, I'm sure we could easily have Mr. Williams' many decades of petroleum land management and landman work qualify for that. But we will move on to our Exhibit B. Mr. Williams, please explain to the board what's depicted here for purposes of this cause and the 4 wells that we're dealing with today.
So this is a plat of the 4 DSUs that the wells that are on the Bridgeland 4 pad. These are the different different DSUs that those wells go into. We have designated out here. Last time we talked about the difference between some of the fee leases and the Indian leases. And so we have identified each of the different Indian leases that these wells are part of.
And the DSU for, this is the DSU for all 4 of these wells, correct?
Right, there are 4 different DSUs. Each well goes into a different DSU. Okay. We name our DSUs creatively. These are all horse names. So we have the Shire DSU, the Clydesdale DSU, the Walker DSU, and the Arabian DSU.
And each one of those DSUs is approximate 1,280 acre DSU?
Each of these are a 1,280 DSU, give or take a few acres, depending on the section, non-conforming.
Okay, thank you. I will move to Exhibit B, or Exhibit C, sorry. Can you explain the purpose of providing this,
Yes.
this carve out from one of the relevant leases?
One of the questions that we had in the last hearing, as we said, that the reason why we began drilling quickly after the acquisition was because of the term limits on a couple of the leases that we had, some of the Indian leases. This is a paragraph out of those leases. It's the continuation paragraph that explained that that shows that we began operations before the end of the term of those leases, continued over the term of those leases, but had an obligation to put those wells on production, that we couldn't just drill and hold because of the terms of the lease at that time. We needed to put them on production to hold the lease and keep those DSUs in good standing.
And importantly, I think, am I correct in understanding that good faith and workmanlike prosecution is still nonetheless capped at those 30 days?
It is capped. We needed to have continuous operations, and so we had to continue operations without interruptions. And which is what we did with this. We began our operations in September and continued drilling and then completing and then putting them on production when we finally got them on production the 1st of May.
And so it's lease terms like this and similar lease terms, importantly including tribal lease terms, which are even more restrictive than this, that is the reason that these 4 wells were drilled when they were drilled.
These 4 wells were drilled, and once we acquired this acreage here in August, we knew that we had very near-term terminations. We had been working for that, getting the right approvals for drilling, so that we could drill and get this acreage on production. We did have these type of restrictions that would made us move forward. We had made the plans to continue on with this, and we actually recognized, as Dustin will explain a little bit more in the future, that we expected that we would be able to capture all of the gas off of this pad. The second thing is that when we drilled this pad, when we designed this pad, all 4 wells were necessary to be drilled at the same time. That is due to the way in which we configured the facilities and put the facilities together. It'd be very difficult to drill some of these wells immediately and then come back later and drill more and add more facilities at a later time. So part of this whole operation was to drill all 4 wells at the same time on one pad so that we could put the facilities together in a workmanlike fashion.
Okay, we'll move on to Exhibit D. Can you please describe what's depicted here in terms of timing and ownership?
So this timing here is each of the wells, when their spud date is, date of first production for these wells, the date that we finished our completion test. We've got the DSU size and how many and what the difference of the division of tribal acres and fee acres is, which was one of the questions that we were asked to answer in the last hearing.
Okay, and so looking at this, all of these DSUs, all 4 of these wells have either a majority or 50-50 tribal leasehold coverage.
They each have a large percentage of tribal acres in them.
Okay. We'll move on to Exhibit E. And I know there's a lot of content in here, Board, but this was born of specific questions of the Board and the division regarding how does flaring work, or what is the nexus between the Board, flaring, the Utah Department of Air Quality, and the Environmental Protection Agency. And can you please describe those interactions as you understand it, and WM's compliance with the same?
Let me summarize this here, and we went back and looked at the rules and also talked with our consultants about our air quality, made sure that we were in compliance with air quality. The summary is that as long as flaring is the domain of the board, it is not the domain of air quality, although we have to report our emissions to air quality and the APA in our annual reports. So there was no additional permitting that's necessary under the air quality rules for flaring, but those emissions are captured in our reports and will be captured as we make further reports. I did go back. I did verify that those reports have been submitted timely, and then they will continue to be submitted timely.
And so those reports are both to the DAQ and to the EPA, correct?
Yes, there's two different annual emission reports that are required, one to the Division of Air Quality and one to the EPA. And although we had just submitted the 2024 submission, which didn't include this because the flaring hadn't occurred, in our next round of submissions next year for the 2025 year, these emissions will be included in those reports.
Okay. And so based on your understanding, that final statement that WM is in compliance with state and federal air quality requirements presently, because it's before the board, is that correct?
Yes.
Okay. We'll move on to Exhibit F. If you could please describe the timeline, which I believe includes some of the Lee and Goat Pad as well because of the proximity of the infrastructure.
And I can speak to this, but I believe that this is actually will be better through Dustin.
Okay. All right. If we're going to do that, then I know the next slide is engineering.
Yeah.
And so I will ask a couple of just cleanup questions here. The first being, were exhibits A through D prepared by you or under your supervision, direction, and control?
Yes.
Okay. And to your understanding, was
through E?
Or A through E? Yes.
A through E.
Yes. Sorry. And your understanding is that notice as required by Utah law and board rules, both mailing and publication of the request for agency action and the notice of hearing in this matter was properly given to all parties whose legally protected rights may be affected?
Yes.
Okay. And notwithstanding what has been discussed in prior hearings regarding really the board's decision here between the lesser of two wastes, I guess, do you believe that the relief sought today will protect correlative rights and prevent waste and maximize resource recovery?
Yes, I do believe that.
Okay.
I will say that I don't agree that it's the lesser of two wastes, but that's my opinion.
You're supposed to agree with your lawyer.
Okay.
Okay. I have no further questions for Mr. Williams. We'll leave it to the division and board.
Division, do you have questions?
Sure, just some clarifications, Mr. Williams. If we could go to Exhibit B, I think it was. Yep, that's it. In Exhibit C, you talked about your continuous drilling provision and your drilling obligations. In this exhibit, we look at the Walker and the Arabian drilling units.
That's correct.
They're shown as HBP, those leases. Could you describe your need to drill on those leases?
Sure. So those ones are although the paragraph that I represented in Exhibit C really reflected the leases in Section 11 and Section 1314. The leases in the Walker and the Arabian DSUs, that lease is actually a little bit different. So let me explain that, and then I'll explain the need for that. There's two reasons for the need to drill those with that. That lease happens to be a vintage lease. It was actually entered into effective in January of 1950 with the Carter Oil Company. It has been around since that time, being held by different various vertical wells there. So its primary term actually expired in 1960, but has been held by production since that time through small vertical well production of those wells there. When we acquired this interest, we looked at those wells and said those wells are at their end of life, end of their economic life. We would really like to replace those wells with with horizontal production, which is one of the reasons why we wanted to do that, rather than to struggle with some stripper well production and trying to claim that that was holding the lease. So we felt there was an immediate need to replace the vertical well that was holding that lease with some horizontal good production. The second reason, again, as I mentioned before, was the need to be able to drill all 4 wells on one pad at one time, so that all of them can be outfitted properly. It would have been very difficult. It can happen, and it does happen, where we come back and retrofit the facilities and try and add those on. But we looked at this and said, this is what we need to do, is drill all 4 wells on this pad at this time. Now, recognize this was back in August and September of 2024, when it was our understanding and our belief, as Dustin will show you more fully, that we had a line of sight to capture all of this gas here. And so we went ahead and began that operation. Of course, once you start the operation, based on 2 of those wells having that continuous operation requirement to production, we had to begin and end all in a uniform fashion, which is why we put all of these wells online and as of May.
Okay, thank you. And as to the tribal leases, do they contain similar royalties? Are they all different?
So the leases in 405 West are all come from the Blacktail Ridge Exploration Development Agreement. They have the same royalty. And I believe that's 15%, if I remember right. The lease, the vintage lease, is an older lease. It has a 12.5% royalty.
Okay. And just for confirmation, during flaring, are you paying royalties to all the royalty interest
Yes,
owners?
our intent is to pay royalties for every MCF that is produced. Is required for the tribal leases, and will happen for our fee leases also.
Thank you, Mr. Williams. No further questions.
Board, do you have questions? Mr. Walker?
Yes, on this slide here, the Arabian well only goes half. You cut off at the east half of section 17.
Yes.
Are you going to explain that, or is that up to?
I'll let Dustin explain that better. Okay. This has to do with our alignment, and this is a 2-mile DSU. We permitted this under previous spacing. Because of the timing, we hadn't gotten the larger spacing order that we now have for this area. So the 2-mile DSU was what was available when we permitted this well and needed to drill this well. Since that time, we now have the option to use 3-mile spacing, and we are respacing this in our future development. The Arabian well was programmed to accommodate those 3-mile DSU, or those 3-mile laterals in the future for development.
Okay, thank you.
Board, do you have any questions? Mr.
Yes, I have a
Galecki?
quick question. So we speak about you had to get production out of it. And it says, primary term was 10/3 of 24. So when did you have to have production by? I'm just trying to understand the date.
So there isn't a date specific for production. The date specific was that we had to begin operations before the end of our primary term. And we had to continuously work to production.
So you had if I'm following, so you had to start that before 10/3 of 24.
That's correct.
It's probably in another slide, but when did you, this was drilled before or after the goat, those other holes?
This was drilled immediately after the goat pad. So I don't remember exact date that we began operations on our goat pad.
Can you show the map again to show the distance between where this is relative to the goat and other pads?
Let's see, do we have a map that shows?
Might be all the way at the end. Hang on. There you go. That one?
Yeah.
Yeah, that would work. So this pad is 4 miles, 3.5, 4 miles north of the goat pad.
And both Goat and Lee, when did you start drilling on those?
So Lee was drilled in 2024, early in that time. Dustin might be able to give you a better number on that. And the goat pad was drilled after the Lee. I think we moved immediately from Lee to goat and then to Bridgeland 4, if I remember right, with the drilling rigs that we had there. And I think we did the completion in the same order.
So you probably had a fair indication that you'd get abundant gas in this.
By the time we started completions, I think we knew that the goat pad was producing, and again, I'm going to leave this more to my expert on this, but I believe that we understood that there was more gas than we thought was going to be there. But it wasn't until shortly after that time that we went, oh, we don't have the capacity that we thought we were going to have. And that's the problem that we ended up with here is more gas than we thought we were going to have, a number that I think Dustin give you a better idea of, and much less capacity than we anticipated that we would have for takeaway. So that's where our spread came from.
I'm sorry, were you finished? Yeah. The wells or the tribal leases in the Bridgeland pad were already held by production before these wells were drilled. Is that correct? This was not the first well on those leases.
On the leases in Section 4 or in Township 4 South 4 West, that is true.
Okay.
On the leases
4 South 5
on
West.
4 South 5 West, that is not true. Those were.
This is the initial test well.
Yes.
Thank you. Do we have any further questions for this witness? Okay, back to you, Mr. Chicken.
I would like to call my next witness, Dustin Trike. Mr. Trike, if you could please state your full name and association with U.S.M for the record.
Yep, Dustin Bradley Trike, the COO of U.S.M, so I handle all things operations.
And have you testified before this board in the past as an expert in petroleum geology, or petroleum engineering, sorry?
Yes, sir.
And did you attach a educational and work experience resume to these exhibits?
Yes, sir.
And based on that and his prior testimony before this board and prior recognition as an expert, I'd like to offer Mr. Trike's testimony today as expert testimony in petroleum engineering, subject to voir dire by the board and or the division.
Division, do you have questions?
Yep, no objections to Mr. Trike.
Board? Please proceed.
Sure. So I'm going to just start with Exhibit F here, which is our timeline exhibit, and ask Mr. Trike to please describe what's depicted there.
Yep, this should look pretty familiar. We just covered this one, but our timeline starting from August of 2024 through today, July of 2025. Major milestones was our acquisition, and when we started drilling, which was August of 2024, we drilled Lee, Goat, and Bridgeland 4 in order. We laid that rig down on New Year's of 2024. We started bringing wells online. Goat was really our issue in January of 2025. Lee was actually in the pipeline for a period of time, so we didn't realize we had the major gas issues until 2025. We submit our first flaring RAA. We come in front of the board in March. We've been in front of the board every month since then. Major milestones from that point forward is we got Lee off of flare in May, and then we got Goat off of flare 2 weeks ago. So we've been able to extinguish the first original 2 pads that were the issue, and now we've set our sights on Bridgeland 4, and hence why we're here for this cause number.
Okay. I'll move on to Exhibit G, which the board has seen this exhibit before, but just so the board is aware, we're updating it every time you see it with whatever has happened in between so that the board can see the progress being made. Can you please, Mr. Trike, describe what is shown on Exhibit G?
Yep, so just some broad updates here for our Phase 1 compression project. Everything in green is a built pipeline that's operational and ready to go, both for gas and water. Since the last time I was in front of the board, we've continued to make progress on our compressor station dirt work. That's our antelope pad compressor station. We should be wrapping that up in August. We have acquired all of our right-of-way from our rewater facility to the Williams Brundage tap. The only exception to that is we're just waiting on approval for the small BLM component right north of the tap. We don't foresee an issue with getting that in the month of August as well. So we changed that from red to yellow. Now that we have all of that right-of-way secured, we're in a position where we can start construction. We anticipate having pipe delivered in the next 30 days. We've been working very closely with Williams in the last month. We actually had our on-site with Williams yesterday at the Brundage tap to discuss engineering design and kind of the logistics of how we're getting tied into them. We upsized our connection agreement from a 50 million a day tap size to a 75 million a day tap size. So that actually pushed our capital commitment up slightly to 2 million. For us as a team, looking at our gas numbers coming off Bridgeland 4 and rerunning it on our 5-year plan, it made a ton of sense to upsize that tap now before we get 2 years down the road and wish that we had another 25 million at our disposal. So we're going to upsize to 75. We're still working with the Bride team really closely on our connection across the street into Rewater. This is our nearest term quick solution to getting into the Brundage tap. I mentioned this a couple times, but working with Williams, having our own tap built and operational is likely not going to be ready until Q1 of 2026. And so for that reason, we're going to work with Bride directly. They already have their own tap and they have their own pipeline with capacity. So as we get our compression stood up, we'll tie into Barry's system right there across the street from Rewater, and we'll lean on their pipeline for a 6-month or so period until our tap is complete. From a timeline standpoint, our biggest concern 60 days ago, and this remains true today, is just equipment delivery. I don't have any great news on equipment delivery today, but nothing has really changed from a timeline standpoint. We still anticipate most of the bigger pieces of equipment arriving in late August through October. We're going to kick off construction at the end of August, and that's going to include a lot of cement and steel structural work. For your specialized equipment like dehighs, we're going to do as much of the work as we can before they arrive, and the minute they arrive, we're going to plumb them in, and hopefully that will accelerate our timelines. So overall, for Phase 1 compression, I still see a November commissioning date on our plant, and it is an all-out sprint to accomplish that from today forward. So yeah, that's a broad overview on Phase 1 compression.
Okay. We'll move to Exhibit H, and if you can please describe, these are some of the other options that WEM is using to capture gas while the main project is going, correct?
Yes. So the Ross pad, would be a joint venture with a flare gas mining company. We've submitted our air permit back in June. We anticipate approval of that in the next 30-ish days. We're working with DAC to speed up that time frame, though they've been good communicating back to us the process it's working through, and I believe we're making good headway there. The units could be deployed relatively quickly because they're already in basin with another operator, and we see this as a 3.5 million a day outlet that could be stood up by the end of September. I include the chart in the bottom left to kind of give a sense of what is 3.5 million a day. What does that mean to WEM in this moment? The other blue bars represent our current sales outlets for gas. You can see, a 2 million a day outlet for us is pretty standard. And so having the ability to go to the flare gas miner with 3.5 million, this would be our biggest output for gas that we currently have. So general terms have been agreed upon, and we're working through our gas purchase agreement with the flare gas miner as we speak, and we hope to have that wrapped up and continue to push this project forward because it's going to help us bridge a gap between here and the end of the year.
Okay. We'll move to Exhibit I, which is getting into the nuts and bolts of volumes. If you could please describe what is depicted on Exhibit I.
Yeah, about a month ago, we had a discussion about what was our forecast and a visualization of where we came up short. To give everyone some background, I forecasted all of WIM5 in this acquisition back in that May 2024 timeframe. So I've got 3 charts here, and these are all specific to the Bridgeland 4 pad. The gray lines represent what my expectation was. The green, red, and blue are the actual oil, gas, and water numbers and what they look like versus my forecast. So I'm gonna start in the top right with oil production versus forecast for Bridgeland 4. As a team, we were really excited because the wells jumped out right away from an oil rate standpoint and we're beating my forecast. You can see I have that ramp period and then decline in the gray. We're pretty spot on from an oil forecast standpoint. We beat on the front end, but these wells are declining how I anticipated, and our peak rates were very similar to what I anticipated. I feel really good about our oil forecast. One caveat here is the wells are still flowing. They're not on artificial lift yet. So I'd anticipate a little bit shallower decline as we get wells on lift and maybe a little bit of bump in oil rate. I'll transition to the bottom left side, which is the water. Water, similar story. I might have missed on the ramp period, but the overall decline for the pad, I feel like I kind of nailed that one too. My mistake is gas. So in the bottom right chart, you can see I had originally forecasted these wells with the slow gas ramp based off of some Oventive and our own data that was to the east of Bridgeland 4. These wells from a gas standpoint have kind of jumped off the chart from the get-go. And I think my peak rate was decent. Like obviously if I could reforecast this with the data I have today, I would nail it, but hindsight's 20/20. So to illustrate to the board in the division, where did I miss on gas forecasting? It's right there in that bottom right chart. So at that bullet point, I think the higher than expected volumes of Bridgeland 4 have prompted us to upsize the critical infrastructure. That is really important. We're looking at this data, actively making changes to the infrastructure we're currently building.
Okay. Exhibit J. Can you please, this one's actually, it looks more complex than it is, but please describe the differences between, again, looking at what you had thought early versus what what you thought will be available in terms of infrastructure for takeaway and what was actually there when the rubber met the road.
I'll start with the bullet points. So in early 2024, we had identified sales taps through our neighbors that we felt like were going to be sufficient based off of the volumes they were giving us for potential takeaway. So our initial estimate is that we would have just over 20 million a day of available capacity through our neighbors' infrastructure. We ended up making all of these connections, but the actual takeaway capacity ended up being a fraction of what we had originally forecasted. So the top right bar chart, the left side is the planned. That's what we were looking at as a team. Hey, we're going to have 20 million across partner 1, 2, 2B, and 3. The right bar chart, that is the actual. What did those, so the blue corresponds to, like the darker blue corresponds to darker blue. So you can kind of get a sense of what we had it sized at and then what our actual throughput through those same taps are. You can quickly see that we're moving a fraction of what we had originally planned. And then I included the red bar chart at the top to illustrate the shortfall. This chart is a little bit old. I made it a month ago. We have come down off of that gas number just slightly, but it does give you a sense that, it was pretty clear that we could have handled the amount of gas that we're producing today had our initial plan even been 80% of what we anticipated. It ended up being less than 50%. So you pair that with higher than expected gas production, and then you have a major shortfall, which has led to us being here asking for the flare allowance. The bottom half of the slide is a map just illustrating where we're selling gas currently. So I'll start on the left side, which is the west side. We're selling to Berry, FOURPOINT, Berry again, and then Scout at Rewater. And just a couple other outlets we had. You know, we had a bigger outlet with Berry that we had to abandon due to a right-of-way issue. And then also just continuing to show the Williams tap and the Williams pipeline that, you know, we're fortunately moving ahead on that project, and that's ultimately what's going to that bar chart in that top right would dwarf anything we have currently. A 75 million a day outlet there is going to jump off that chart pretty easily. So that's our ultimate long-term goal.
And Exhibit K is designed to get at the issue of waste as a general matter. Can you please describe what is stated and depicted there?
Yeah. While prudent steps should be taken to prevent the excess flaring of gas, protecting the oil production through temporary flaring is not considered waste. Compared to oil, the gas delivers a fraction of the value, and you know, as a team and as a company, we're doing everything we can to protect the oil production because we believe that ultimately is the most value to all the stakeholders. So the top right, that's our Springbok 7H well. This is a well that's been online for over a year. It's a 2-mile Uteland Butte in our infrastructure. We have not been flaring there. We're actually selling that gas to a broader market. To give a sense of what oil versus gas revenue looks like, the oil is the green bar. Within the last 12 months, it's $6 million in gross revenue. Gas hasn't broken 500,000. I think it's about 250K. So again, just trying to emphasize that these are oil wells, and even when we have gas into sales, the oil production, even if you lost 5% of it, would hurt all stakeholders. So I also have that bullet point, like a 5% reservoir energy loss due to excessive shut-in duration would reduce the value of all the stakeholders' interest by more than the value of the gas being flared. We have one particular situation across the funds. We did a joint venture with Altamont back in 2022. We drilled 8 horizontal wells. We have an example of when you restrict a horizontal well early in its lifetime, what it can potentially do to that well's productivity. So the bottom right chart, I've got 3 horizontal wells with similar fracs, same horizontal target, similar timing, just they're all drilled, they're all modern horizontal wells drilled in the last 3 or so years. You can see the blue well here is our Powell 42H well. Operationally, it went really smooth until we had a coil drill out where we left a BHA behind in the heel. There were 4 other wells on the pad. We were in a rush. We left that well with that BHA in the heel with the idea that we'd come back and get it at a later date, but we would produce it for the time being. We bring the pad online, and that well struggled immediately out of the gate. And as expected, it had an obstruction in the heel. For about 180 days, we fought it. We had some periods of shut-in time. We had periods of, obviously it was pretty restricted, but we eventually removed the fish. We drilled out the well. So it's a fully, from a lateral perspective, it doesn't have an obstruction anymore, and it shouldn't have an asterisk on it from an operations standpoint, in my opinion. But that being said, when you look at that well versus its neighbors who have a cleaner flowing period in that first 180 days, we see a 60% reduction. We don't think that that's geology driven. In fact, that this well is more basin center than some of its neighbors that are further east and arguably in worse geologic rock. Like I said, the fracs are the same. The main difference here is an operational issue we had early on, and the choice to try to flow this thing back, well, it was very restricted, and we hurt this well. So a quick search on OnePetro, looking for situations like this in the engineering community. We did find a paper. Granted, it wasn't the Uinta Basin. I'd love to have another Uinta Basin example of this, but it was an unconventional basin with horizontal wells. You can pull this right out of the abstract, but the excessive shut-in durations can lead to near wellbore energy loss and reduced oil recovery. I feel like our Powell 42H is an example of that.
And I think we have one more after this, two more, okay. Exhibit L is a familiar slide again to the board, but this one is focused solely on these four Bridgeland 4 wells. Can you please describe what Exhibit L is depicting in terms of volumes for oil, wellhead, and flared gas?
Yep. So this is the cumulative oil and gas rates off of the Bridgeland 4 pad. That's the only pad that we are flaring on at this point in time. As of last week, we were around 4,000 gross barrels of oil a day and about 4,500 MCF a day that was being flared. There is one update to this slide that didn't make it in. As of this week, we've captured about 1.5 million worth of gas off of this pad. So we continue to find ways to squeeze more gas into our infrastructure. And if this chart was updated through today, you would see that red bar would actually tick down by about 1.5 million. So we continue to, it's good news, and our anticipation is that we can have this handled quicker than our original timeline, similar to how we handled the Lee and Goat pads.
Okay, moving on to Exhibit M, again, a comparison of production rates for gas, water, oil for all four of these wells. Can you please describe the main themes being shown here?
It's just additional detail on a well level. I think the top left chart's my favorite chart in the last, first 3 months of production on this pad. Each well is at or above 100,000 barrels of cumulative oil. And then the rest is just kind of illustrating some decline on gas and water, and just a table at the bottom to show some averages over those periods of time. It's just additional detail.
Okay. And I believe that is your last slide, so I'm going to few housekeeping items here. First is were exhibits F through M prepared by you under your supervision, direction, and control?
Yes, sir.
Do you believe the relief sought, the flaring exception sought for these four wells will protect correlative rights, prevent waste, and maximize resource recovery?
Yes, sir.
And then if you can offer it, the request for agency action in this matter requests a per well per month flaring amount from today going forward of 50,000 MCF per well per month. Is that number still accurate for the ask today, or has it gone up, or has it gone down?
It's still accurate, and we've kicked this around as a technical team, and there's one caveat here. None of the wells are on artificial lift yet. The ability to get them on artificial lift and see what that gas production does, I would feel really confident giving a number to extend us 60, 90 days. My request would be that we maintain that flaring allowance, knowing that we're likely not using it. We're already capturing at that pad, and we'll continue to capture more, and then seeing the wells on artificial lift will ultimately give us an idea if we're way above or below. I anticipate that's a generous number that we can live under.
And then as far as keeping the board and the division apprised, were the board to grant the request today, my understanding is W.E.M. would offer, there's one board hearing in August, and the next board hearing after that is September 24th. That's actually the flaring exception date that we're asking for in this RAA. You would be available and willing to update the division in an informal meeting sometime in August of 2024 on developments from today to that time in terms of additional gas captured, infrastructure status, correct?
Absolutely.
Okay.
Did that capture on the mic? Yeah.
I think it did. I have no further questions for Mr. Trike.
Division?
Yeah, just a couple questions. If you could please go back to Exhibit H. Could you just give a little bit more explanation of the Ross pad, like what it is? This isn't a pad that will have well bores on it, correct? This is a mining.
Yeah, as it's currently planned, it won't have well bores on it. But that being said, like in the future, if we could recycle that surface for future wells, we potentially could. But this would be dedicated to, essentially we would be providing surface for a flare gas miner to set up their gen sets and their actual mining containers. So they need quite a bit of surface area. That's one thing that we definitely underestimated as we started conversations with them, is they need a pad similar to what we're drilling 4 to 5 well pads off of. So this would be specific to it would be a takeaway point where they're going to take our wet gas, put it into a genset, turn it into electricity, and then the electricity will create Bitcoin.
And so that number there, Ross pad, designed for 3.5 MMCF per day, that's how much you anticipate that could take away?
Yes, and that's with a 12
Wow.
genset unit estimate. So there's a couple things, right? They're leaning on our gas analysis, and they are leaning on their ability to use 12 units to convert that gas into electricity. The reason being for $3.5 million and the 12 units is it keeps them under a certain air threshold. If you go over that number, you extend your runway on that air permit. So
Okay.
from a timing standpoint, that was our magic number for quick.
Okay, thank you. If we could go to, let's do Exhibit J. So during your testimony, you indicated your planned takeaway, but what you had planned didn't pan out. Could you explain why, what happened there? Why, even the connections you made, why they weren't adequate?
We have a fully steel infrastructure that allows us to move more gas at a higher pressure. Our neighbors have fully poly systems. And, hindsight 2020, looking back on this, it's really tough to estimate what someone else can move through their infrastructure. But I think the quickest and simplest example is that when you're taking a gas that's in higher pressure, bigger diameter steel pipe, and then forcing it into smaller diameter poly pipe with a lower operating pressure, you simply can't move as much. You're physically choking that gas movement. So it's not so much a downstream issue. They've got compression, they've got sales points. It's a matter of going from big to small, in higher pressure to lower pressure.
And so during planning phase, that material difference wasn't known.
It was an oversight. We leaned on the estimates they gave us, which were, I think round numbers. If they gave us a $5 million estimate, we ended up only being able to move 2 to 3, and that across 4 different outlets adds up.
And so, I believe you already spoke to this in your testimony, but just for our perspective, at the time of the drilling of the wells on the Bridgeland pad, you believed that you had sufficient takeaway for these wells?
We did.
All right. Lastly, we've talked about the amounts that are being flared right now. Are all 4 wells currently flaring?
The way our facility is set up, yes. All 4 wells are flaring, but they're also flaring at a reduced amount because we've started to divert gas from the flare into our sales system. So that's the 1.6 million I mentioned, is getting diverted into the sales system, and the 3.5 left over is going to the flare. So another highlight, we're flaring 3.5 million today, when a week ago it would have been almost 5.
All right, thank you. No further questions from the division.
Board, do you have questions? Mr. Galecki?
Yeah, I had let's go Exhibit M, I think. It's a little bit of an off question, but the water rate, where are you disposing of that?
All of our water is on pipe, so it moves through the same pipeline infrastructure that our gas is in. It's the same bundle, so it moves south and to the east to our rewater facility. We've got produced water ponds there. So that water is essentially a closed loop. We'll take produced water, we'll store it in a pond for a period of time, and then we'll send it right back to frac.
Yeah.
And there's some spikes in the water data. It's just not clean. The meters occasionally will get a little out of whack, and then we have to adjust that data. So we should clean that up a little bit.
No, that's good. Okay, thank you.
Mr. Church?
So, congratulations on getting the goat in. It shows your great effort. Basically, you're wanting now to have Bridgeland take up what we had given you for goat till September the 24th. But then you say that your compression is not going to be in until November 1st. So what do you anticipate between September 24th and November 1st? Is there going to be a request to come back and extend that, or do you anticipate not having that need?
I hope not. I anticipate that we're not doing that for a couple reasons. I think we're going to continue to find small tweaks in our system to pack more gas into the line as is. I think with the flare gas mining with another 3.5 million, that's a huge outlet. And then my compression being stood up in November, all those things need to align to not come back. But with that being said, I think we continue to show that we're going to find a home for the gas in a shorter time frame than we originally planned. So, yeah, my hope is that I'm not coming back.
Board, any other questions?
Yeah.
Mr. Walker?
Okay, back on Exhibit G, and maybe it's not on Exhibit G, but the general question is, okay, so you got Barry and you got your other 4 partners, and then you've got 1 flare gas miner. Where are the other 4 going to market?
Yes.
Sales markets, okay.
They are.
So they're all going to interstate pipelines?
Yes.
Okay. Are you selling it to those folk, to the interstate pipeline system, or to the other producers?
We sell it to the other producer. It makes it a lot cleaner. If we have a sales point with a meter right off of our infrastructure, we sell it there.
Okay. All right, great. On Exhibit K, you used Springbok as your example?
Yes.
Okay. Is that typical of all the other wells that you've got?
Yeah, I would describe Springbok as like it's a mid-tier 2, tier 3 Uteland Butte well, so it's in line with production expectations, and all of our wells have the same composition of sales gas. Like they're all going relatively to the same place and under the same sales regime. So I would anticipate all of our wells look very similar to
And most of your GORs are about that same sort of number?
We only have Uteland Buttes online today, so the GORs are pretty dang similar.
Okay. That's all I have. Thank you.
I have a couple questions. Going back to Exhibit G. So this map indicates that this line is built all the way to the Berry high pressure tap, that the pipe's in the ground, you're using it. What's the diameter of the pipe?
We have a combination of 12 and 8 inch.
Okay.
The 8 inch is legacy. So when we first acquired our first 5 DSUs in this neighborhood about 3 years ago, we were laying 8 inch. We only had 5 DSUs. We weren't sure if the wells were going to work. We are actually in the process of upgrading everything to 12. We're going to run 12 from Rewater to Brundage. So we'll have a majority of 12 inch in our system with a little bit of legacy 8 inch.
And so the yellow line, are you participating in building that line? What's the status of that line? Is that line built or?
Right away is secured. We have the pipe should be delivering any week now. The only reason we wouldn't start that line, for instance, next week is that our timeline with Williams is looking like Q1 of 2026. So I have limited resources on the dirt work side. That same group of guys is, I could put them on building the Ross pad to have that ready to go, or put them on this pipeline project. We're going to prioritize them on the Antelope compressor station and Ross, just because the Williams, our own tap into Williams, isn't going to be ready until 2026. I've got some time on that pipeline section.
So in order to get under the 50,000 MCF, do you have to have that yellow line done, or are you, among all the things that you're doing, are you going to be able to get down to a reasonable amount of flaring?
Yes, the yellow line needs to get built in this calendar year. It's just a matter of prioritizing the dirt work projects we have in the short term. For us, like, our highest priority is the Antelope compressor station. That is the kind of the linchpin on this entire plan, is having that operational. So I'm putting all my dirt work resources towards that, and then we'll transition east, get going on that pipeline. But we, like I mentioned, as soon as Williams is ready with that tap, we're likely going to be waiting on Williams.
And last question, on this Exhibit L that shows the Bridgeland production, what happened in July to reduce production? Was that just putting wells on, or?
In July, the
yeah.
chink down we
Yeah.
we had an emergency shutdown event
Okay,
for less than 24 hours.
okay. Board, do you have another question? Mr. Walker?
Yeah, Mr. Williams partially answered this, but on the Arabian well, you're only going 1.5 miles.
Yep.
What's different about that situation that's on Exhibit A?
Yeah. You'll notice that Arabian is clearly shorter. It's about a 7,000 foot lateral. If we could go back in time, we should have drilled that as a 4-mile lateral. There weren't any 4-mile wells in the basin yet. It was shortly after that we saw that SM was going to do the 4-mile spacing. So yeah, perfect world. If we go back, we drill that well 4 miles. But at the time, we were really comfortable with the 3-milers, and 4 wasn't on the table yet. If we didn't drill Arabian when we did, you're leaving that 7,000 foot of Uteland Butte behind. And I say that because as we have it planned, we're going to be drilling 3-milers from that section line moving east. So we drilled Arabian at 7,000 feet because we plan on drilling a well that will start at its toe and drill another 12,500 feet to the east. We were essentially in a bind where do you create a worse parent-child issue by not drilling that well and then trying to infill it at some point? You really wouldn't want to infill with just one 7,000 foot lateral. Your economics on that would be pretty poor. So it was just a matter of trying to balance a transition between 2 and 3 mile DSUs. We inherited the pads and the permits as is, and we're up against a timeline. So yeah, long story short, I say it all the time. I wish we'd have drilled Arabian as a 4-miler.
Okay, thank you.
Seeing no additional questions, we're back to you, Mr. Chicken.
Given our timing here, I think the board's well aware of, both how we got here and the diligent and resourceful efforts of WEM to take a situation that they hadn't planned on being in and try and turn that around in furtherance of their CEO's stated goal. They view this as, this is their home basin and this is where they want to be, and they've spent hundreds of millions of dollars to extend that basin and to figure out where it's at. And when you're on the frontier, things like this happen sometimes. I think we've shown that for the most part, these there were things that could have been done better, and there have been lessons learned, but there was certainly no intent to be in this situation. And WEM is hopeful that we can resolve this situation wholly by September 24th. If we look at this as a 10-well problem, 6 of those wells stopped being part of the problem 2 months ahead of schedule, and we're hopeful that we can make the same thing happen with these other 4 wells. WEM will update the division in August if the board were to grant this order. Let's say this. Either WEM or I will appear in September, and if it's just me, it's going to be really great news. And if it's all of us, we may be asking for a little bit more. And if that's the case, then we would give you all of the reasons and that we would need that more time. But make no mistake, the target right now is to not need it by that time. And so based on that, I would first ask the board if we could admit Exhibits A through M to the record.
So admitted.
And respectfully ask the board to grant the RAA as requested and provide an extension and a variance, an exception from the board's flaring rules for these 4 wells on the Bridgeland 4 pad, allowing the per well per month flaring of 50,000 MCF per well through September 24th and the board's hearing on that date.
Thank you. Board, do you have any questions? Do we need to deliberate on this? I'm sorry, division?
Yeah, could we have a minute?
Okay.
We'll be quick. We know we're all
I'm
hungry.
counting.
So the division, we're here today because we're constrained by regulatory rules. An operator they can flare up to 1,800 MCF a month under our rules. If an operator's in violation of that, they're guilty of a Class 2 violation. We issue them an NOV that gets time to cure. If they can't cure, it's a $1,500 a day penalty per well. But if an operator wants to flare more than that, they can request that from the board. And that's why we're here today. To request that from the board, by rule, there's certain things that the operator has to spell out. They have to spell out the need, the justification, test of the gas, and so forth. And U.S.M's done that in their RIA. They've met that burden there. But just from a regulatory standpoint, from the division and development in the basin and future operations, the division's not in favor of excess flaring. It just can't be. By rule and by statute, we can't do that. However, we are cognizant of things that come up, and we are able to, stomach when certain situations arise where an operator anticipated they would be able to take away gas and things came up that they couldn't handle. Those things are excess gas beyond what was anticipated. There are also when you anticipate you had pipelines that would be available for takeaway, and then they just weren't there when that opportunity came along. We've heard testimony today from U.S.M that this was the case. They thought they could handle the gas. They thought they had takeaway, but when it came time to actually take away that gas, that wasn't available. So then there's this balancing act. What do you do when our operator comes before the board and requests excess flaring? The board has three options. They can allow their request, they can restrict production, or they can take any other action they want. We've also heard testimony from U.S.M today that curtailing shut-in of other wells in the basin has caused problems for wells in oil production. And as we know, oil is far more valuable in this instance than the gas it's producing. So with that in mind, that's where the division stands. I mean, we can't be in support of excess flaring because our rules don't allow that. However, we are able to understand why that needs to happen. And so we leave, again, this is a board matter. We leave that up to the board to decide how they will proceed in this matter.
Thank you for your comments.
Thanks.
Board, would you like to discuss this? We're going to take 10 or 15 minutes here to discuss. We'll be back. We're going off record.
One.
We are back on the record. I think we're ready for a motion on this matter.
Yes, Madam Chair. I move that we approve the RAA as requested.
I'll second the motion.
It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed?
Nay.
I'd like to take a roll call vote, please. Mr. Galecki?
Nay.
Mr. James?
Nay.
Mr. Church?
Aye.
Mr. Walker?
Aye.
And chair votes aye. Motion passes.
Thank you. I will prepare the order.
If you would prepare the order for me,
Yes, ma'am.
I would appreciate it. And we'd like to suggest to the division that perhaps they look at the 1,800 per day flaring and see if that's the appropriate number, that anything above that is excessive, should those base limits be changed at all. And with that, I believe we are, the matter's concluded.
Thank you very much.
Thank you for your time.
Board, appreciate all of your time. Thank you.
Thank you.
And we are going to break for lunch. We'll be back at 1:35.
One.
Thank you. We are back online to finish the last two matters on the agenda. Number 4 is docket number 2025-032, cause number 997-04, in the matter of formal rulemaking to adopt the R644 carbon sequestration rule pertaining to section 40-11 and the obtaining of primacy for class 6 injection sequestration wells.
Thank you. Andrew Haynes with the division, Andrew Haynes, Assistant Attorney General, representing the Division of Oil, Gas, and Mining. Board, we're here because the division filed a notice of agency action to commence formal rulemaking on April 9th, 2025 to adopt R644, which is this carbon sequestration rules. This is done in part of the division's process to acquire primacy from the EPA for oversight over UIC Class 6 carbon sequestration wells. The division came before the board on May 28, 2025, and requested that the board commence the formal rulemaking process and allow the division to submit the proposed rules to the Office of Administrative Rules for publication. The board granted the division's request to commence formal rulemaking, and the proposed rule was filed with the Office of Administrative Rules and published in the Utah State Bulletin on June 15, 2025. The minimum 30-day formal public comment period was provided from June 15, 2025 to July 15, 2025. No public comment has been received since the May board hearing and the publishing of the proposed rule. The division and the board have taken the actions to comply with the Utah Administrative Rulemaking Act. Therefore, the division now asks the board to adopt R644 as published to become effective as of today's date, July 30th, 2025.
Any discussion from the board? Does this require a motion?
I believe so.
Could I have a motion to accept the rules?
I'll make a motion to accept the request, or to accept the rule 644 carbon sequestration rule as requested.
All in favor, please say aye.
Aye.
Any opposed? Please proceed, Mr. Haynes.
Thank you.
Thank you. Moving on to docket number 2020. This says 4. Is that incorrect?
No, it's correct. It's from last year.
Okay. Docket number 2024-075, cause number 997-03. In the matter of formal rulemaking to amend the R649-9 Waste Management and Disposal Rule to the Exploration and Production Recycling Facilities Rule. Mr. Haynes.
Thank you, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. So during the March 26, 2025 briefing session, Natasha Bailiff with the division indicated that since we had amended our 649-9 to the exploration and production recycling facilities rule, the division had identified places in our rules that referenced the prior R649-9, which was a waste management rule that needed to be removed or changed. Therefore, we requested a removal of R649-6-2, which was the waste crude oil treatment facilities from our current R649 rules. The board made a motion and approved the division to commence formal rulemaking to remove this section. Based on this motion, the division published the removal of R649-6-2 with the Office of Administrative Rules, and it was published in the Utah State Bulletin on April 15th, 2025 for the required 30-day publication period. The minimum 30-day formal public comment period has been met under the Utah Administrative Rulemaking Act. The division has not received any comment since the March board hearing or the publishing of the proposed rule. Therefore, the division now asks the board to adopt the removal of R649-6-2 in the new R649 rules with these changes as published to become effective as of today's date, July 30th, 2025.
Do I have a motion to amend R649-9?
I'll make the motion that we amend the rules, R649-9 as presented.
Do I have a second? Second. Been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Please note motion carries. Mr. Haynes, please work your magic.
We'll take care of it. Thank you.
Thank you. With that, do I have a motion to adjourn? I believe that was the last item.
Just a question, did we need to set an effective date on when this rule is?
They're making it effective today.
Today.
Yeah.
Excuse me, I missed
Do I have a motion to adjourn?
it. I move we adjourn.
Second? Second. All in favor? Aye. We are adjourned.